Good morning, everybody. If we can make a start. I think everyone can probably hear me because I can hear my own voice sounding slightly mechanical. But there we go. So everyone at the back can hear okay, I take it? Yeah, fantastic. Okay, well, good morning and a very happy new year to everybody. It's just after 9:30 on Monday, 12th of January 2026. Welcome to this public inquiry into the application by Fred Olsen Renewables Limited for the proposed Lees Hill Renewable Energy Park at Lees Hill near Duns. My name is Nick Smith. I'm a reporter working for Scottish Government's Planning Environmental Appeals Division, also known as DPEA. I've been appointed by Scottish ministers to prepare a report and recommendations for them about whether the proposed Lees Hill Renewable Energy Park, DPA reference WIN-140-10, should or should not be granted consent under Section 36 of the Electricity Act 1989 and deemed planning permission under Section 57 of the Town and Country Planning Scotland Act 1997. That proposal includes 6 wind turbines, 69.83 hectares of solar arrays, a battery energy storage system, also known as BESS, control buildings and substation, access tracks, up to 3 borrow pits and associated infrastructure. Throughout this inquiry, I am likely to refer frequently to this as the proposal or the proposed development, so that's what I mean when I say those things. This proposal would exceed 50 megawatts of generating capacity and so is a national project determined by Scottish ministers. This public inquiry was triggered because Scottish Borders Council, Planning Authority, objected to the proposal. Various public bodies, community councils, businesses, along with other groups and members of the public have made written representations supporting or opposing the proposal, and those are all before me, and I will be considering all of them as part of my recommendations to Scottish ministers. Now, before we get underway with today's proceedings, I have a number of procedural and housekeeping matters that I need to cover first. That should take me between 5 and 10 minutes. So do please listen to what I've got to say, as it will assist all parties in the smooth and efficient of a timely process. Very first thing you will have noticed is that we are broadcasting live on the internet today. So firstly, all inquiry and hearing sessions pertaining to this case are being broadcast live on the internet for the public to follow. They will also be recorded and stored as part of the DPA's webcast archive and will be capable of repeated viewing. By participating in these virtual sessions, participants are consenting to being filmed and to the use and storage of those images and sound recordings and any information pertaining to them contained in those for webcasting and training purposes and for the purposes of keeping historical records and making those records available to the public. If you want to find out more information about that, you can go onto the DPA section of the gov.scot website and see the privacy notice, which talks about that. Colleagues from DPA are looking after that side of things for us today. So we've got Connor, David and Craig, who are running all of our IT systems today. So thank you to them. So all of this means that you can follow the proceedings from home as well as here in person or from elsewhere, and so you don't always have to be here in person. So now there's a few notices that I need to go through. So the first is on the back of what I've just said, social media and photographs. For data protection and privacy reasons, we request that participants do not take any photographs or other recordings of their own during the session unless those being photographed or recorded have consented to this, and for the record I don't. So I think that sorts that one out. There was a pre-examination meeting held in September 2025 to make the arrangements and guide the procedures of this public inquiry and its consideration of the proposed development. That meeting can be found on the DPA webcast library if that's something you want to have a look at, using the reference of this case, which is WIN-140-10. And the minutes of that meeting can also be found on the DPA website using the same case reference. So the process for today and the coming days, for everyone's benefit, I'll just run through what's going to happen. So this public inquiry will comprise 4 hearing sessions. The agendas were circulated to participants before Christmas, and some spare copies are in the room. I think those of you in the public gallery area should have access to one near you. Please don't take those with you because I don't have access to a printer while we're here, so they'll be here again if you want to come another day, if you can leave those behind when you finish today. Today we will commence shortly with the first hearing, which covers cultural heritage. I've allowed 2 days for this, depending on the level of detail we need to get into and how long those matters take to discuss. If we manage to get through everything today, then we won't need to return tomorrow to do the second day. However, we will come back obviously on Wednesday the 14th, when we will be discussing the hearing session covering landscape and visual, including cumulative and residential visual amenity matters. So that's programmed for Wednesday and possibly into Thursday again, depending on how we progress the discussions. And then on Friday there are 2 hearing sessions. The first will cover policy matters and immediately afterwards draft conditions. Except for today, all hearing sessions will start at 10 in the morning, 10 a.m. So a little bit longer to get here. The conditions hearing will follow the policy hearing, and I can't yet be certain exactly what time that will commence. It will depend on how long the policy hearing takes. For all sessions, we'll take a mid-morning break of about 10 minutes, perhaps around 11ish, that sort of time, depending on where we are on the agenda. And we'll take between 45 minutes and an hour for lunch, usually from about 1 o'clock. I'll look to finish each day around 4, but I'll probably take soundings in the early parts of the afternoon just to see what people are thinking, if people are able to stay beyond 4, if we think we might get through things in the day. So I'll take soundings on that. And then I'll formally close the public inquiry at the end of the draft conditions hearing on Friday. Participants will then have an opportunity to submit closing statements and summaries of case, and the timings for the submissions of those have already been set out in the minutes of the pre-examination meeting. All of the hearing sessions will take the form of a roundtable discussion that will be chaired by me. It will be based on the agendas that I've circulated before Christmas and will involve only the participants who are seated at the table, although I know Mr Campbell and his colleague are joining us for today. You'd asked for a desk, but you're not participating today, that's correct. So, so the public bit of the public inquiry means that you get to watch it happen and you can listen to the discussion. This is not a public meeting where everybody gets to stand up and say their piece about anything they want. If I think we're deviating from the matters on the agenda at any point, then I'll bring us back to the matters of discussion. Excuse me. And if you're not familiar with this process, you will notice that from the agendas, we're not discussing absolutely every single matter. And that is because we have previously agreed that sufficient information has been submitted on the majority of matters to assist me in making recommendations to Scottish ministers. So we are therefore focusing on the remaining issues that I need to seek further clarity on. And therefore, if you made representations supporting or opposing the proposed development, as I said earlier, I've got those and I will be taking all of those into consideration. All documents have been submitted electronically and can be found on the relevant pages of the DPA website using the reference I gave a few moments ago, which is WIN-140-10. The applicant has also put together a document list that contains web links directly to the DPA website. And I've also asked the applicant to bring some laptops. And for those of you seated in the public gallery, if you look up and to your left, there should your right, my left, there should be a couple of laptops. So those are available to you if you want to follow proceedings on those, and one of the members of staff from the applicant, I'm sure, will be happy to assist you in finding documentation if you want to follow. There is also a large cardboard box sitting behind you on the other side. Yes, just up there. And there are some paper copies, I understand, of visualisations in there. So if we're discussing any visualisations and you want to have a look at those yourselves and follow, then you can get that down and open those up. Those are there for that too. Site inspection, as you are perhaps aware, I carried out site inspections of the site itself, viewpoints, settlements, routes and surrounding areas in late September 2025. If I need to visit anywhere again during or after this week, then I will do so. As before, that will be unaccompanied. If you see me out and about, I'm a nice person, so I'll say hello, but what I can't do is stop and have a chat with you about the case. So that wouldn't be fair on other parties. So some other housekeeping things. We're not expecting a fire alarm today, so if it goes off, it's real. So if that happens, then please make your way to the nearest exit. There is the main exit to the right, where we came in, and just through to the left, where its facilities are just down the stairs in the room just there. The kitchen is available for everyone, so there's a kettle and some cups in there, so do help yourself to that. There's quite a lot of equipment in the room today, as you've seen, so do just please take a moment to note where there are any cables. Don't want anyone tripping, so just please be aware of that risk. Can we make sure all mobile phones or devices are turned off or to silent? Better make sure mine is. Okay. If any participant, or the reporter for that matter, is taken ill during proceedings, then we'll adjourn to ensure the appropriate medical attention is sought, and then we'll liaise to work out when we can reconvene. And that moves me on now to courtesy and behaviour. I would remind all participants and everyone who's observing of the importance of being courteous with each other throughout these proceedings. You will no doubt hear people say things that you don't agree with, but please be polite and respectful. Please give other parties the time and the courtesy they need to express their views and give their evidence and answer the questions in the same way that you would expect this to be done for you. I need to hear what everybody's got to say. I know that there are different points of view on these matters, after all, that's why we're here. I do not expect to have to listen to things like cheering or clapping or tutting or calling or heckling or any of that sort of stuff. Therefore, if you're participating today, your job is to address the points on the agenda or to be quiet and listen to whoever is speaking. And if you're in a public gallery, then your job is even easier because you just need to listen. The principles of courtesy and respect for other participants extend beyond the confines of this room, and also request that those principles are followed if those taking part today wish to comment on proceedings via social media, so please be aware of that. And as mentioned earlier, photographs or recordings other than those being webcast today by DPA should not be made or published unless those featured have consented to this. Again, for the record, I don't. Are there any members of the press with us today? No? Okay. I had noted down about weather updates because we had back-to-back weather warnings all last week. I understand, at least when I last checked this morning, that there were no weather warnings for today, but I'm happy for us to keep a watching brief on that, and we'll take notes about that. Temperature in the room as well. If we've got the heating on, if people suddenly find themselves feeling a little bit cold, let us know, and if they found themselves feeling a little bit warm, then also let us know. I think we're okay. I don't know if the main door's been left open or not, so if there's a... No, thank you. So at least we're largely protected from the elements. So we'll also keep a watching brief on the temperature in the room. Building security, as ever, people are reminded to take valuables with them as they leave. I'll try and remember at the end of the day to remind everybody to make sure you've got your valuables and your car keys, because we're staying in Berwick, so and we've got the keys, so it might be a bit difficult if you've left your car keys in. So we'll try and make sure everybody's out of the building and has got all their stuff at the end of the day. Okay, that moves me on then to the introduction of parties. Can I now invite each of the parties to introduce themselves? So can we have the applicant, please?
Thanks, sir. Good morning. Hear my own voice. Marcus Trinity, constructed by Amy Howard of Wright Johnson Mackenzie. I'm a solicitor and a King's Counsel. To my second left is Amy Howard. To my left is Fraser McFarlane, my witness in this session. To Amy Howard's left is Pip de Klerk of Wright Johnson Mackenzie. And to her left, Emily Galloway, Senior Project Manager at Fred Olsen Renewables, the applicant. And in this session, you'll be hearing from Fraser McFarlane in the main, but also from me. Thank you.
Thank you very much. And for the council, please.
Good morning, my name is Sarah Thompson, solicitor for Scottish Borders Council. Immediately to my right is Keith Elliott, Archaeology Officer, and slightly further down the table is Kyle Wise, Planning Officer. Today we will principally be hearing from Mr. Elliott.
Thank you very much. Before I move on to cultural heritage hearing session, I just need to remind parties that the applicant circulated Microsoft Word copies of the statements of agreed matters the back end of last week, so parties should have those. And those are the identical content, but the format allowed content that had previously been lost from the electronic sticky notes when it was PDF'd to be available to parties. So that has been resolved, I understand. You'd also, I think, in your email referred to not Cronal wind farm decision, but I think you realised afterwards that that was already submitted, and I think I had responded to you not realising. I think our emails had crossed. So I'd asked you to submit it, but actually that was already submitted and it was already on the document list. So that's there already. I also understand that Mr. Campbell and the applicant are in the process of clarifying the applicant's technical queries in relation to an item we'll be considering later in the week with regard to landscape and visual.
Sir, I'm able to tell you that those technical queries have been answered. The photographer was taken ill and was delayed in supplying the information. But he's now done that, and I've given a hard copy to Miss Howard. When she indicates, or if she indicates that she's happy with it, I'll let you have a copy as well.
Okay, so did you want to say anything?
That's my understanding.
Very well, okay, and we'll be picking up that matter in the week in any case. Okay, thank you for clarification on that. And the applicant had also asked whether it would be possible for advisors to dial into the conditions session on Friday. Unfortunately, with the notice we had, it wasn't possible to marshal and test and pack the relevant equipment. So I think I'd mentioned, I didn't know the answer at that point, but I think I'd said to you in the email, if those parties wanted to attend in person, then I was happy for them to do that. Otherwise, I think we'll be left with closing submissions as being the mechanism. So do you have an update? Do you intend them to attend, or do you need to speak to them?
So we're encouraging the relevant people, either two noise experts, to talk to each other to try and resolve the situation before we get to the condition session.
Okay.
May I just mention that I'd quite like to be involved in that discussion in relation to noise, because I do have an expert witness. He was hoping to be able to dial in, but if that's not going to be possible, I will now have to check whether he can attend or not. And I would appreciate Mr. Trinick keeping me informed as to how his discussions have progressed, so that I can contribute either at the session or by way of the closing submission.
Do you want to respond?
Of course.
Thank you.
Okay, thanks. Right, thank you for clarifying all those matters. Okay, are there any other questions about anything I've just said, or any matters that participants need to raise with me, Mr. Trinick?
Just one matter. So the council responded just before the inquiry, and no complaint, to the statement of agreed matters on cultural heritage, making one or two amendments. Okay. I'm entirely happy that amended document comes in, although perhaps the changes made could be explained. But I think they do help. So
I'm happy to pick up those bits as we go through the agenda, if that's probably the most sensible thing. And are you suggesting to me that there's been a modified document between the pair of you, or is it just that you've reached a kind of a verbal agreement and the document?
There is a modified document which I circulated to Ms Howard over the course of the weekend. Not huge changes, just clarifying a couple of points which we can perhaps address in that element of the agenda.
That's fine. Well, we'll pick them up as we go through the agenda, and if there's a document, if there is a clarified position on your agreed matters that are agreed between you, then we can talk about the submission of that once it's concluded. Okay. Was there any other points from me before? No. Okay. Right. Well, in that case, we'll move to the cultural heritage section. So this is expected to use all of today and possibly through into tomorrow, depending on progress. I think it's possible we could get through it today, but we'll just see how we get on. As I mentioned earlier, for those not familiar with this process, a hearing is a roundtable discussion, so it's chaired by me. The matters of discussion are the ones based on the agenda, so if you've got a copy of the agenda in front of you, you can follow that. It focuses on the matters that I wish to seek further clarification, so that's its focus. As I mentioned earlier, if I think we're moving away from the agenda in the discussions, I'll bring us back to that. Does everybody have access to a copy of the agenda? I know there's a few in the public gallery, so people can possibly share those. As I mentioned, I'll look to take a break about 11:15, and then probably about 1 for lunch, and then we'll just take soundings on where we are, I think. Okay, so moving on to the agenda then. So matter one is the clarifications from hearing statements. So I think we'll take this in two sections. So we'll deal with A, and then we'll deal with the next bits. So I'll just read through each of these bits for everybody's benefit, and then we'll progress our discussion. So I'm going to focus on the first bit first. So the council does not appear to have conducted its own alternative assessment, but instead appears to substitute its own observations and findings in place of the applicant's. And my point A is that synopsis correct? And if not, how should the reporter treat the council's objections and hearing statements? So I'll come to the council first, please.
This statement is not correct. Or that's not
Perhaps you could move the microphone a little bit closer to its. Thank you.
No, the statement is not correct. The archaeology officer, i.e. me, has taken under an assessment which was carried out of the initial planning application, and the hearing statement prepared followed that. That was an assessment carried out of the submitted materials of that planning application, and that sent to the planning officer as part of the normal consultation practices, and also the cultural heritage statement for the inquiry also sent on to the planning officer and the solicitor for the council.
Excuse me, sorry. Can I ask you just to bring that a bit closer? I suspect a number of parties are just struggling to hear. You might need to just sit with it right in front of you. Do you want to just give that a test?
Okay, as I was saying, the cultural heritage statement followed the planning application's response that I made, and that was my assessment, that was my workings out.
And when you refer to that that second document, is that one that's before me in the document list? Are you referring to the 31st of March 2025 response by the council, which I understood to be the committee report? Forgive me, I'm looking for the document reference. So that everyone can follow.
13.5.
13.5, just a moment.
Yes, I can confirm that.
Sorry, Mr. Elliott, you were saying?
Yes, I can confirm that. That is the document that was sent on that day.
Sorry, can you just remind me of the reference number for that?
It's 13.5 in the core document list. It was submitted fairly late, so there is no URL associated with that, I think, yet. But it has been sent by email, and I can provide it again by email today if that would be helpful.
That's okay, but it's a document that's in front of me nonetheless. Okay, 13.5. Right. Okay. So this is that, and that document 13.5 is not the 31st of March 2025 response. It's the information that informed that response.
Yes, it's
okay.
dated 23rd of January 2025.
And Mr. Elliott, you were saying that forms your assessment of. Therefore, my synopsis was not correct because the document you've just described for me is the one that contains your assessment of that information. Have I understood that properly?
They both contain my assessment. The cultural heritage statement, the latter of the two, is the digest of the planning application response.
Did you want to say any more before I invite the applicant to respond?
No.
Mr. Drake, Mr. McFarlane?
Thanks, I'll deal with this. One of the problems we've had is to know precisely the scope of the council's case. We understood from the reasons for objection that it was Derrington and Great Law, the cans on that hill, and the can on Derrington and Little Law. Subsequently, and as recorded in the still draft statement of agreed matters, there are three further assets noted in paragraph 4.2 of the draft statement: Bedshield Cairn, Dunside Hill Cairn and the Cairn on Hen Law, which have been added, and there are cumulative effects asserted on the undesignated twin law cairns. But then we prepared our hearing statement, or Mr. Farland did, on that basis. But then we received the hearing statement from the council, which threw us in somewhat disarray, because paragraph 4 of that described the scope of the council's evidence. Subparagraph 1, it was fair enough. I'll wait for you that in front of you, sir, I think.
And this is the council's statement that you're referring to?
Yeah, that's the 13.1. On the third page, internally, paragraph 4.1 says the council's evidence will focus on the suggested scope of the cultural heritage hearing session, but then goes on to list 6 matters. The first matter, subparagraph 1, we understand, save for some odd CD references, which I think have now been clarified. Paragraph 2, though, baffled us because it went much wider than the assets in question for Lease Hill and referred to experiences in Northumberland, and we're still a bit baffled as to the purpose of that paragraph. No doubt we will hear. Paragraph 3 then referred to assets which had not been listed in the reason for objection, nor within the statement of agreed matters. These are the Iron Age forts at Reclue, that area there, which were indeed covered in the 23rd January 25 report by the council, but which did not appear as a point of objection either in the reasons for objection or in the statement of agreed matters. So those are new to us, and we would take issue if the council now sought to give evidence on that basis. Paragraph 4 is just a statement that certain views to and from hill forts are recognised, but doesn't add anything further to the case. Paragraph 5 is purely a landscape observation, which has nothing to do with cultural heritage. Paragraph 6 asserts direct impacts, by which we mean physical impacts on assets as a result of construction, which are recorded in the statement of agreed matters as capable of being covered by condition, and which have been covered by condition 27. So, although I hear what the council says, we remain a little curious as to the scope of the council's case, and we'd like some clarification of that.
So, Mr. Elliott, obviously it's been suggested that some of the matters that you're raising here were not in the original response by the council on the 31st of March 2025. They may well have been in your own analysis of the one that you just referred me to from the 23rd of January, was it? But that did not appear to form the council's position that was communicated and until recently was advised by the submission of 13.5. Can you just explain that?
The comments that I gave in 4.1 paragraph 2, the Northumberland comments that you mentioned there, then those are some of the parallels that were...
Sorry, can you speak into the mic a bit more, please?
The comments that I made in 4.12 and the paragraph with the Northumberland comments there were those in mind, as was mentioned perhaps further on, that I was thinking of for the similarities between the Lees Hill, the case with the Cairns on Twin Law, the Divingtons, the Bedshield, and so on.
So is your reference to them that you're making an analogy to... Do you want to just explain a bit more? I'm struggling to understand.
They are similar cases where there are similar monuments, albeit in Northumberland, admittedly, but they are similar monuments, and they show that the lengths of wider views have been identified of significance to those landscapes in particular, likes of the Weather Hill cairn. You can see the likes of the beside side, the Hare cairn. You can see the black stitchel sign. So they have been identified as important within those sites, and I would say that they are parallel sites to those under discussion here.
So to make sure I've understood this properly then, the examples that you're giving in your hearing statement, section 4.1.2, those are, in your opinion, cases where the circumstances are similar, and you're not saying that the proposal would have adverse impact on those assets. Have I understood that properly? Or is that what you're saying?
Yes, they are parallels of where views have been identified of longer distances, referring to both cairns and also other landscape features.
So you don't want me to treat. So you don't want me to treat you as saying the proposal would have adverse impacts on the named assets here. You're advising me about.
They are parallel cases. They are not going to be impacted by any proposal here.
Did you want to say any more before I invite the applicant back in?
No.
Mr. Trinick, you've had a chance to, you and Mr. McFarlane had a chance to
hear
that. Does that answer your kind of concern, or do you have other things to say?
I have no idea. I think that I read paragraph 1, I'm not concerned about. Paragraph 2 I read as being contextual information, which falls short of alleging any additional impacts, but it's contextual or associative, whichever way you want to put it, and that Mr. McFarlane can deal with as and when requested. That doesn't give us a difficulty. Now I know that it's what it's intended to be. That's okay.
So is this no longer then an area of dispute? You both understand what this is referring to, or you might not necessarily agree in the context of professional opinion, or you may agree in the context of professional opinion, but it's been clarified what the distinction is here.
So as I understand it, and I'm saying it clearly so as to...
Okay, you had a chance to hear that. So is that accurate? Is that a fair representation?
Yes, further on in the matter that we'll be discussing, number 4, you've asked about what things persuade us, and those are analogous things to bring in.
So obviously later on we'll be picking up some of the nuts and bolts of this. So yes, in answer to my question, my synopsis was not correct. You had done some analysis which has now been submitted, which informed the Council's response, which was already before myself and other parties. And therefore it is that informs matters, and we've just clarified, I think, the point on 2. Okay, if there's nothing more on that bit, I'll move on and we'll do the second bit, and then I'll allow, once we've all discussions been had, I'll allow the applicant to close. Mr. Trinick, you want to come back on something?
Still think we need to clarify 3. Putting it very bluntly, is Mr. Elliott now bringing Reclue Iron Age forts into the Council's case? Yes or no?
I'm just looking. I mean, we do have a point on the agenda later on that covers the hill forts, which I'd specifically asked about. I'm happy for you to respond now if you want to. We'll not go into the detail about the nuts and bolts of it, but if you want to respond to that point, I think it'd probably be helpful just to clarify for all of us.
They are there, they will be impacted, but it is not the hill forts are there, they will be some impact, but that is not the basis of objection. It's more towards the cairns.
Did you want to come back?
Now I know it's not part of the objection. I'm content. There's also the issue of 6 as to whether that really is an objection, bearing in mind the condition which has been put forward, the direct impacts. I just want to get clear of the total scope of the Council's case before we get into the rest of the agenda.
6 does not form part of the objection in relation to this matter.
Okay. I suspect a number of these matters that we're discussing first thing just now will help shape what we're going to pick up later on. Hence my slight reluctance to jump into the detail of them now, because obviously we've got a kind of structured session about that, but I'm content we've clarified that. If parties are happy, then there's nothing more to say on that bit. I'll move on to B and C, and then when we've done B and C, I'll let you round up and close if you want to. Okay, so the second part of matter 1 about clarification from hearing statements. The applicant's consultant has carried out an assessment in Environmental Impact Assessment Report Chapter 10, which considers setting impacts effects as different to indirect impacts effects in EIA terms. The Council's hearing statement, paragraph 4.1, section 1, refers to severely adverse indirect impacts upon specific prehistoric cairns that are inside and outside of the red line boundary. It goes on to describe how it has considered the views to, from and between the cairns as significant in their location as monuments. This implies that the Council is considering setting impacts or effects as indirect, whereas the EIA appears to treat them as a different matter. And so I've asked, and I note as well, I think you refer in the Council's response to the 31st of March 2025, I think you also refer in that, in section 5 of that, you refer to a number of indirect effects. So I'm asking firstly under B, is the synopsis that I've set out there, is that correct? And C, given that the Council's evidence appears to relate largely to the settings of historic assets, and you can tell me whether you think that's accurate or not, should he, the reporter, treat the description of indirect impact in the Council's hearing statement, paragraph 4.1, section 1, and indeed elsewhere, as referring to setting, or does it mean something else? And I think here I'm just seeking to clarify whether, if it's about setting, can I translate comments that the Council makes about setting to, can I translate that and compare that with EIA consideration of setting? Or did you mean something else when you said indirect? I just want to make sure I've properly understood everything.
The synopsis is correct. I would equate indirect impact with setting. They're not exclusively the same. Setting could be impacted in other ways. There are other indirect impacts too. So it could be that there is noise. It could be smell, it could be the changes of groundwater, it could be things that are being required of work to get material to a site, rather than the direct impact of the site itself.
I see. So in your description of indirect, then you've taken setting to be part of that because setting is not a direct impact or effect on the asset itself. It's on something to which it relates, and therefore, in your opinion, it's indirect. I'm just trying to make, and again, I'm happy to be told I'm wrong, but I understood that there was a distinction that was being made between your evidence and the applicant's in your use of the term indirect, and I just wanted to understand that I could legitimately translate what you're saying and compare it with some of the things that they're saying to do with setting, and that would be a reasonable translation. Have I understood that properly?
Yes, that would be fine by me in that conflation between the two.
Okay, Mr. Trent, Mr. McFarlane, do you want to come back?
Yeah, just to pick up on that, so our understanding of what constitutes an indirect impact, we laid that out in paragraph 10.3.26 of the EIA report. And our understanding of that was derived from page 182 of the EIA handbook, which was jointly authored.
Just give me a second, can you give me that page number again?
182 of the EIA handbook, which was jointly authored by Nature Scotland and Historic Environment Scotland. So document number for that is 001.159. So that's what's informed our understanding of indirect. Now, the definition of that in that guidance for an indirect impact is something which would constitute a secondary process which could lead to physical degradation of a heritage asset. So, for example, you might have a below ground asset which relies on waterlogged conditions for its survival, but if there were to be changes to those hydrological conditions, it could lead to the drying out and the degradation of the asset. So that's how indirect is defined in guidance. Whereas a setting impact is something separate from indirect. Now, certainly in terms of how the council have used the word in their response, they have used it interchangeably with setting impacts, and that's how we've understood the use of the word. But again, there is just the disagreement is in terms of using indirect to cover those secondary processes which might physically impact an asset and impacts on setting. We would treat impacts on setting as a separate thing, but for the purposes of the matters here, we understand it to mean the same thing.
And so to clarify, I mean, I'd made the point to Mr. Elliott a moment ago that setting is not a direct impact, but you're making that distinction, aren't you? And I think what you said to me was an indirect impact is it's that secondary process component that you talked about, and therefore setting, whilst not being direct, is a separate thing. So I suppose you've got direct, you've got indirect, and then you've got something that's not direct, but is also not indirect. It's
yes, yes, I would agree with that. Yeah.
Did you want to respond on what you've just heard at all? Are you happy enough?
I'm happy enough with that.
Okay, I think that brings us to the end of matter one. Did you have anything more that you wanted to pick up under item one before I invite the applicant to close? No? Okay, Mr. Trinick, Mr. McFarlane, was that enough? Do you want to say any more by way of close for that section? No? Happy? Right, okay. Right, we'll move on to item two then, please. Item two is, matter two, clarification from the statement of agreed matters. As I mentioned at the start, a PDF copy had previously been circulated of this. It contained electronic sticky notes. The electronic sticky notes in some cases were cut short. The applicant has provided a copy in Microsoft Word, and that makes sure that those are not cut short. I've got a number of queries about some things that relate to those, but some matters that relate to other things, and I understand as well that the applicant and the council have reached some further agreement. So what I propose is that we'll run through the agenda as we are, and we'll get to the end of matter two, and if there's some issues that haven't been picked up, then I'll allow both parties to say what those are. So we'll start with at SOAM, or Statement of Agreed Matters, paragraph 9.2.1. There is a note in there which states that NPF 4 Policy 11E, Roman numeral 8, may also be relevant. Now, I understand that particular part of NPF 4 Policy 11 to refer to the effects on hydrology, the water environment and flood risk. And it wasn't clear to me whether that issue had been picked up. Later on, it talks about 7, so I'll let you go on. I'll let you.
That was a typographical error and has been picked up in terms of the updated version of the Statement of Agreed Matters.
I had a suspicion that might be the case, but I wanted to make sure everybody had a chance to say. I'll let the applicant come in a moment. So where it said Policy 11E, Roman numeral 8, it should have said Roman numeral 7. And
yes, and that has, the Statement of Agreed Matters has been amended to reflect that.
And I understand, I think certainly in the copy that I'd read, I think it was the following paragraph actually talks, or some of the following paragraphs talk about part 7, and I just wasn't clear. So, did you want to say anything more before Mr. Trinick can respond?
No, nothing further.
No. Mr. Trinick.
We are in agreement.
Okay, I think that's pretty clear. I understand what's happened there, so that's fine. Okay, so the next one is at Statement of Agreed Matters, paragraph 9.5.1, is a definition which the parties appear to agree upon, and I understand that's a definition in relation to setting. At Statement of Agreed Matters, paragraph 9.5.2 contains no text. Now, at the time, I was reading from the PDF copy. I subsequently understand that there's what is actually shown in the Word copy is the scoring out of some text, so we'll be able to pick that up in a second. But a note which appears to say that agreement on the definition is still to be finalised. Some of the text was cut off from the PDF version, and I'm going to read what that all is for everyone's benefit in just a moment. And my queries were therefore, where does the definition in 9.5.1 come from? What does the text in the electronic sticky note refer to? And that sticky note seems to refer to paragraph 9.5.2. Have the parties reached agreement on the matters stated in the sticky note, and what are they? And the sticky note also appears to cut off some text, but I now have that text, but I'm going to read it now for everyone's benefit. So the sticky note in that document read, and bear with me while I read this. Due to receiving SBC's, Scottish Borders Council's, comments on the 24th, 11th, 25. It may not be possible to resolve this before the deadline for submitting the SOAM, the Statement of Agreed Matters. However, we feel that this point would benefit from discussion between SPC and the applicant, and I should say the we in this case, it's the applicant who is talking, so that any difference can be properly understood. This is likely to be of assistance to the reporter, particularly as matters are to be considered by way of a hearing session. Reference made to the consultation response by Historic Environment Scotland 002.013, which finds a significant, and at that point the text stopped, but it continues in the MS Word version, goes on to say significant impact on the setting of Derrington Little Law Cairn, but that the effect of the proposal is below the threshold of significant impact on integrity of setting that we would object. It then goes on to reference, it quotes paragraph 35 of a recent Historic Environment Scotland report, which it says is appended, although I'm not clear that I could see that, so I'll welcome being directed to where that is. Integrity of setting is not defined in policy or guidance. It has therefore been subject to debate at inquiries over a number of years. Consistently, Historic Environment Scotland has only objected to proposals, including the present proposals, where there will be significant adverse impact on integrity of setting. Not all change to setting causes a significant adverse impact on the integrity of the monument setting. So I'll pause there. So that's what that says. So there's a few things to work out, and just bear with me a second while I bring up my documents here so I can see what I'm looking at. Okay, sorry, I'm in the right place electronically. So I'll ask the council to come back first and explain just the points B to E, and just it might be that there's a straightforward explanation. It's just I wanted to clarify things.
My microphone on, there we go. So principally the sticky note relates to 9.5.2, which prior to being scored out stated the parties agree that a significant effect in EIA terms on the cultural significance of a heritage asset does not equate to a significant impact to the integrity of the setting of a heritage asset as per the terms of MP.
And can you tell me where the definition in 9.5.1 comes from, to your understanding?
Perhaps Mr McFarlane would be better placed to assist with that part.
Yes, Mr McFarlane.
Yes, so the definition of integrity of setting, as it's presented in paragraph 9.5.1, emerged from the 2021 Rig Hill public inquiry, and the DPEA reference for that is PPA-310-2034. So that definition was agreed with Historic Environment Scotland for the purposes of that inquiry. It's also been agreed with Historic Environment Scotland for the 2025 inquiries for Hill of Fare. DPEA reference for that is WIN-140-10, and also for the Nist Hill inquiry, which Nist Hill with an N, yeah. And the reference for that is NA-330-001. So we can provide copies of the inquiry reports for those if that would be useful. This is a definition that has emerged and has been agreed with Historic Environment Scotland over a number of inquiries. So that's where it came from, and it was obviously presented in paragraph 9.51 of the Statement of Agreed Matters, and it wasn't contested.
So I understand where that's come from, and this is a point that upon which you both agree. So that's the agreed part. The not agreed part, unto which the sticky notes agree, is the wording that's crossed out in 9.5.2. Just let me. So I suppose in part, in answer to my questions in C, D, and E, you don't agree on the points that are made in.
No.
And accepting that you don't agree on it, but in trying to understand what that text was saying, would it be correct that it was saying, if you find something to be a significant impact or effect in EIA terms, you don't necessarily find it to be significant in policy terms? I recognise you don't agree with it, but is that the gist of what that... Do you want to say, and I'll let you respond?
Yeah, that's an accurate summation, yeah.
And that was a point you didn't agree on?
Yes, that is my understanding.
So to help me understand, so I suppose conversely then, you are saying that if there is a significant effect in environmental impact assessment terms, then it must be a significant effect in policy terms, and if it isn't, it isn't. Is that what you're saying by not agreeing to that?
I think I was looking at it in this particular case, maybe not general. From what you've said, it sounds like a general point that it doesn't equal, if it's, like say, EIA terms, it's significant, doesn't mean that it's against policy, but which I agree with, but so maybe that's incorrect.
So the statement, obviously, the statement of agreed matters is what you're agreeing for this particular case, isn't it? So you're saying in this particular instance,
yeah,
you are saying the fact that some significant effects may have been identified in EIA terms, you consider those to then constitute significant policy effects, and therefore you can't agree to the premise of what that crossed out text says for that reason. Is that a fair understanding?
I think in this particular case, yeah, we don't agree that there's no policy conflict. However, yeah, I think the generalised statement in all cases is correct. So, yeah.
Little law, and yet did not find that a matter of national interest such that Policy 7H2 would be breached. In other words, there's no necessary equation between an EIA significant impact and a breach of the policy.
I understand what you've just told me. So yeah, I mean, I suppose the point here in my understanding the nature of your agreement and disagreement is that first of all you agree on what the definition of the definition set out in 9.5.1 is, but in the context of this particular case and the factors that we'll go on to no doubt discuss in detail, you are not persuaded that that statement that's crossed out in 9.5.2 was accurate, and therefore you didn't agree to it. Whereas Mr. Trunick's point, Mr. Trunick's side, the applicant takes a professionally different view to you, but I think what you were both saying was it is plausible it is hypothetically possible that that not every single significant effect you find in environmental impact assessment terms would automatically translate into a significant policy effect. But in this particular instance, you felt that it did, and therefore you couldn't agree to the statement.
Yes, I think this was viewed from the context of this particular case rather than in more general terms.
And I'll let you come back in a minute. So, I mean, we'll get into the nuts and bolts of it in a bit. So, Mr. Trunick.
I think I'd just add to that. It was the word hypothetically, which made me a little nervous. This is a very common HES response on a number of applications. Yes, we find significant adverse effects on setting in EIA terms, but we do not find a breach of policy 7H2. And indeed, in the recent document 1240, NIST Hill Inquiry Report for HES, at paragraph 35, they say integrity of setting is not defined, don't mind that. It consistently has only objected to proposals, including present proposal, where there will be significant adverse effect on the integrity of setting. Not all change to setting causes a significant adverse impact on the integrity of a monument setting.
And this text you're quoting, this is the text as I read a moment ago that's contained in the sticky note in the statement of agreed matters. Yes. So, and therefore that quotes, I think, paragraph 35 of And is that from one of the decisions that you quoted to me? Could you just tell me which one? Because I think I initially started reading it that it was referring to the submission that they'd made in relation to this case, but it didn't link with that. So I think we.
Yeah. So that was from the Nist Hill Wind Farm public inquiry, and that's document number 012.040.
I've got a note of that. So yes, they're saying in that particular. Okay, so
and that's paragraph 35 of that report. Yep.
So it's my use of the word hypothetical that has triggered that rather than the council. So I should stress that point. But I think from what I'm seeing, so if we take that point that's made by Historic Environment Scotland, accepting that point, the council's position is that in this particular instance, this falls into a category where the significant EIA impacts and effects translate into significant policy effects, and therefore you don't agree with the statement, and that's the rationale at least. Okay. Did you want to come back on that?
Just an additional point from Mr. McFarlane, please.
Yeah, it was just to point out that I mean, setting is only one aspect of the cultural significance of a monument. You know, we've stated this in paragraph 31 of our hearing statement. The cultural significance of a monument is the sum total of what is valued about that. Setting is one component of that, but it's also the physical fabric of the monument, and things like its associations. And so that definition is recognised in guidance. So, you know, whilst you may have an impact on one aspect of cultural significance, that shouldn't then be inflated to mean that the entire cultural significance of the monument is significantly adversely impacted.
Just to add to that, that document 10.4 is the EIA handbook, and in Appendix 1, paragraph 43.
So that's sorry. Historic environment policy.
Has, sorry.
Yeah.
Which reference is that? Tell me again.
10.04 is historic environment policy for Scotland.
But that's the document referring to the EIA handbook,
Yeah,
isn't it? Yeah.
It's
Sorry, it's document 12.4, not 10.4. My apologies. In Appendix 1, paragraph 43, Hes states that impacts to setting should be assessed with reference to the degree that the proposed effects on the setting contribute to those aspects of setting that contribute to the asset's cultural significance. So they are drawing that thread together as between setting and significance. Now, the point I will make in closing submissions arising from this is that, well, of course, policy 7H2 is part of the development plan and you've got to apply it. I will be saying that you have, as a matter of a material consideration, to have broader regard to the impact of the development of cultural significance in the round. It's just fair warning of a closing point, really.
Okay, thanks for flagging that up for all of us. Did you want to come back on any of that because there were some additional points that were made?
I don't think we've anything further to add at this point.
That's fine. If no one's got anything more on that bit, then we'll move on to the next part. And again, we might get through this particular bit relatively speedily. So this is Statement of Agreed Matters, paragraph 9.6.1, appears to assume further confirmation is needed on something. And I just wanted to know what specifically is the matter for confirmation, and if we know what it is, has agreement been reached on what that is? I'll let the council go.
The full terms of 9.6.1 are now of agreement between parties. I'm not sure if that is in the copy that you originally had or whether you're able to see the full wording of 9.6.1.
Right, just give me a minute. I think you'd alluded just at the outset to a revised version of the Statement of Agreed Matters that picked up some of the things that both of you have dealt with in between the time of having seen my agenda and having had a chance to discuss things a little further to perhaps clarify matters. And it might be that you've modified
Yeah, I'm not
And-
sure I have the most updated version in front of me, which simply shows 9.6.1 as a clean term of there any comments or condition or have been removed. So it simply reads as a full condition, which I am happy to read out if that would be helpful.
Did you want to come back in before that happens, Mr. Chinook, at all?
Just noting, this is not about cultural heritage. This is about the updated cumulative landscape and visual baseline. That's what this comment is about.
Yes, it was to do with, I believe, a scoping stage proposal,
Well, sir,
or previously scoping stage proposal, perhaps.
in the CLVIA of October 25, which is document 1.223, there is table 1 on internal page 2, starting on that page, which is updates to the cumulative baseline, and that goes on quite a long way. That was what we were seeking to agree as part of the statement to agree matters.
So it's a point of fact, I suppose.
Fact, purely fact.
Okay.
Nice.
Okay. And that fact has now been
It
established.
has, yes.
It sounds like there's an updated version coming to me. I think we'll get this session out of the way, and then I think that'll allow you both to settle those matters, and then I can get the finalised statement of agreed matters. Pretty quickly, I'm just wondering. Obviously, you're going to be here this week. Is that? It's probably a bit much to ask for it this week, but I'd quite. Maybe it isn't. I don't know if it's all done.
Updated draft is with Miss Howard. I sent that over in the course of the weekend. These additional points that we're discussing, provided Miss Howard's satisfied, I'm content to forward it on today.
So you probably need a bit of time to look at it, don't you?
It's not going to take long. It's a very helpful update, and we can agree most points. So we will provide you with another version by the end of today. Yeah.
Today, okay.
Yeah.
I mean,
We're done.
it can be tomorrow if that gives more time. If that's easier,
No, let's get that out of the way.
fair enough. As you wish. Yeah. Everyone's happy. Yeah. Okay. That's fine. That can come in if you send that to the office as normal, and then that will find its way onto the system. Okay. Thank you. Right. I think that relatively quickly clarifies that. And that moves us on to so paragraph 9.7.6 appears to relate to the matters above and further discussion. And so my query is, just bear with me a second. There we are. So I think it's the matters, a reference to the sticky note. So what is the particular matter here? What further discussion, if any, have taken place? It sounds like there may well have been some. Where was it intended to get to? What position has actually been reached? And does it alter anything? And I'm going to read out the sticky note as well, because this is one where it was previously cut off. So in the version that I originally had, the PDF version, it said, per comment at paragraph 9.5.2, SBC, Scottish Borders Council, comments were not received until 24/11/25, so it may not be possible to resolve this point before the deadline for submitting the SOAM. However, we feel that paragraphs 9.7.6 and 9.7.7 would benefit from further discussion between SBC and the applicant, and again, we is the applicant in this instance, so that any differences can be properly understood. It would be helpful to understand the reasons for SBC's inclusion of ED9, and that's policy, LDP policy ED9, I understand, given that it does not contain any policies regarding, and then the text stops, but the word copy goes on to say the impact of the setting of scheduled monuments or non-designated assets. Did you want to go first, and then Ms. Thompson?
There are two disputes. One relates to policy ED9. Our note indicated that does not advise on cultural heritage, but actually it does indirectly, because it brings in NPF for policy 11B to F, and E7, of course, within that does advise on cultural heritage. So there is an indirect relevance. We're wrong, they're right, that's fine.
Do you want to respond?
Nothing else to add there?
Okay. So to clarify your
That's a simple clarification. The second point, though, in relation to the renewable energy SPG, we maintain is correct, that does not provide any further guidance on on historic environment. If we can be pointed to it, we'll happily agree, but I don't think it does.
You can come back if you'd like.
I think we might need to review that before I agree to it. Yeah.
Sorry, what do you mean by that?
I need to have a quick check before I agree right now to that point, if that's okay.
I understand. That if it's not picked up in the new version of agreed matters that I'm going to be getting by the end of today-ish, if it's still an outstanding matter, then either if it can be sorted and you can flag it up to me in the accompanying email, or it might be one for closing statements, and if there's nothing that you can, and that will allow the applicant to respond in due course. Does that sound okay?
Yes.
Any more on that particular issue? No? No? Okay. That brings us to the end of matter 2. Did you want to, was there anything that was...
No, that has picked up all the outstanding matters that are reflected in the most up-to-date version of the Statement of Agreed Matters.
Mr. Trinity, do you want to say anything by way of close on that note? Happy with where we are? Okay. Now, we started a little bit earlier this morning at 09:30. We've been going just over an hour, so I was going to propose to continue and get through matter 3, and then I think we'll take a break. Are people happy with that, or people need to take a break just now? No? Right, we'll we'll make our way through matter 3, and then that should bring us nicely up to around about 11ish. So, matter 3, direct impacts. Council hearing statement, paragraph 4.1, section 4. No, wrong, sorry, section 6. Trying to read my Roman numerals there. Section 6 considers there to be direct risk to heritage assets from construction work associated with the proposal. The reporter understands this to relate to Henlaw Cairn, 1550 metres west-northwest of Langton Lees, SM4548, and other potential and as yet unknown assets in the area. However, the reporter also understands that measures are proposed in Draft Condition 17, Construction Environmental Management Plan, and Draft Condition 26, Programme of Archaeology, and he understands that those are intended to protect assets during construction and to make provision for archaeological investigation. So my first point is, are both those parts of the synopsis correct? And if they're not, you can tell me. And is there any outstanding disagreement between the parties on these matters? I know we touched on this at the outset, so I'm happy for the council to
so we
tell us.
noted at the outset that this did not form part of the council's objection, and it is more a matter in terms of conditions.
Mr. Schnick.
Grateful, nothing more to say.
That was quick. So can I take it that the council is content, at least in principle? I know you haven't objected, and I know we've got a conditions session coming up, but the intended purpose of those conditions does the thing that you...
Whilst we are still in discussion in terms of conditions, and that would be dealt with later in the week, the issues raised are should be dealt with by way of condition rather than forming a part of an objection.
Anything? No? Okay, that moves us on rather quickly then. I had said 2 minutes ago we would stop there, but I think we'll keep going, and we'll just find a point around about just after 11 to pause for a comfort break. So that moves us on to matter 4, which is the dispute over findings for prehistoric cairns. So I've divided this into 2 sections. So we'll deal with section A first, and then a very simple format for section B. So section A, what factors persuade the parties that their respective positions are correct for the settings of, and I've listed 3 scheduled monuments here. So we've got Dirrington Great Law, 3 cairns, SM4626, Dirrington Little Law, cairn on summit of, SM4548, and Henlaw Cairn, 1550 metres west-northwest of Langton Lees, SM4548. I'm sorry, I appear to have given the wrong SM reference for one of those. My apologies for that. That's a mistake on my part. And I can't immediately tell which one is the wrong way round. I'm happy for anyone to jump in if they no matter. We'll pick it up as we go along. But in any event, that's. Oh, Mr. Trinick has it.
Hen law is 4548. Durrington Little law is 4638.
Thank you very much. I'll just read that so that everyone can hear. So that was my mistake in the agenda. So it incorrectly says Durrington Little Law Cairn on Summit of. It incorrectly states it to be SM 4548. The correct reference should be SM 4638. Okay. So what we'll do is, in a moment, I'll invite the council to explain the nature of the dispute as it sees it and where the respective position, where each party, when it's their turn, feels that their respective position offers the most plausible conclusion for Scottish ministers. I realise in some instances that parties have talked about the Durrington laws collectively and individually, so I'm happy for you to talk about them individually, but if you feel that you need to actually bring them together to make the points, then you can talk about both of them. But my proposal at least is to start with Durrington Great Law and then work our way through. But as I say, if you feel you need to refer to both of them together because the points just lead you to that position, then that's fine. So I'll let the council go first.
Okay. Yes, if we deal with them collectively, then there are the commonalities of views from all of them. It is the significance that will be affected by both the turbines and, to a degree, the solar panels. That is the differences between myself and the opposite side applicants and their representatives. Yeah. From my background, then I have been in historic environment work for quite a number of years. In most cases, that has been.
I'm sorry to interrupt you. Would you mind just bringing the mic a little closer?
As a historic environment record officer, and engaged in a number of projects which have looked at similar prehistoric monuments. Again, we've mentioned the Northumberland Parrels, which I'm familiar with, and I see the similarities of these monuments to those where those views are important. So there are those interactions. That has been something that has been noted in previous applications. Vinchmure application that I quoted within my planning application response that noted the views. The views are mentioned in the AGS response. We have heard the final line that has been quoted, but there is the mention that there is the significant impacts expected from those cairns. As I say, there's that similarity of views to these monuments to other ones that I have encountered in Northumberland. There are those shared characteristics between these monuments of this part of the Scottish borders with elsewhere monuments of a similar ilk in the Scottish borders and beyond.
And are those similar ones the ones that you described that we were talking about a few moments ago, earlier this morning, in paragraph 4.1, section 2 of your hearing statement? Are those the similarity? Are those the similar ones that you're making?
There are similarities to those ones specifically. There are other articles and papers that I could have quoted and similar sites that I could have cited.
Well, I mean, let's stick to obviously what's been submitted. So could you just take me through... I think you said to me, as I understand it, that there are some similarities in terms of significance with some other assets. I'm just trying to understand the main points of dispute, the rationale for those, and why you're persuaded that your position is the correct one.
There are similarities of the sites themselves. They are all scheduled. They all have their associations.
I'm sorry, which sites?
The Durringtons themselves. There are the number of cairns, both on Great Law individually. There's the 3 cairns. There are the Durrington Little Law and the Hen Law themselves. So there are the similarities between them and the similarities of what their views are looking to do. there are those similarities between those sites and elsewhere, as I highlighted, both individually and collectively, to the likes of these Northumberland examples as well. So there's that shared repertoire that they're feeding into, whatever that is, looking up to the cairns. There is the document that I included mentioning of the Northumberland examples. There's the likes of the Northumberland landscapes chapter, where I've shown that the other people have also recognised the views looking towards the cairns, and there's the views looking between those cairns.
And your contention, and so by the cairns you mean those on both of the Dirrington laws, as I understand it from what you've just said?
Yes, you will have those views between the Dirringtons and beyond, which you will have the views of the wind farm turbines in this case. In the nearer case, the Little Low, then you will have the views looking from that cairn to those turbines.
And as I understand it, obviously the wind farm part of the proposal and the solar part of the proposal sit in a particular direction from the Dirrington laws. So is your suggestion, I'm trying to understand, is it views to the historic assets on the Dirrington laws, or the views from them, or both, that is, in your opinion, affected by the proposal?
It is views between them, between the Dirringtons, where the turbines would be the backdrop. It is also the views from that nearer Dirrington off as well.
Sorry, my apologies. I'm trying to place my mind geographically in the place. So when you refer to views between them, would I be standing on one of them looking at the other, or am I standing somewhere else looking at both of them with? And is it the latter or the former of those, or something else?
It is both of them, but more particularly from the likes of Twinlow cairns or Dirrington, looking over where you are seeing the turbines as backdrop behind.
So it's from places where you would view both of those assets together, and where the proposal would appear with them, and is it that alone, or are there other things that form the basis of your concern?
It is the both. As I say, those views from the likes of Twinlow cairns and Dirrington Great Low towards the Little Low, where you're seeing things behind, but you're also independently having the individual monuments. So the Dirrington Little Low being veneer, you will be seeing the turbines impacting on the setting of that monument alone.
Excuse me. Okay. So yeah, you mentioned the views in particular from Twinlow cairns. So as I understand it, I've seen the visualisations. I've been to Twinlow cairns. So when you look from there, you see the Dirrington laws, and you then see the proposal, and it's that juxtaposition, which, in your opinion, is the one that causes the effects which lead you to have the concerns that the council has expressed. And firstly, is that correct? And secondly, besides that, are there any other? Is that the nub of it, or are there other positions from which you would view them where that concern arises?
That sounds correct to me, that you would be seeing things from Twinlow cairns behind. So behind the Dirrington Little Low, you might not necessarily be seeing the cairns themselves. The setting is how things are appreciated, understood, for the likes of prominence. Well, yes, it is that whole of the hill that is just being marked by that cairn itself. So
could you just say that last bit again?
There is no the individual prominence of the monument is irrespective. It is there. It doesn't have to be something that is immediately visible.
So just because you might not be able to see it doesn't mean it isn't there, and doesn't afford itself the respect and all the rest and the protection that it has, and what have you. Okay. The second part of my query for you had been, So I understand what you're saying to me about those kinds of the positioning and what have you. Are there other locations from which, was it solely that one, or were there other positions in the vicinity of the proposal from which the council was concerned that the proposal would adversely impact to a significant degree? That was part of your concerns, or was it solely the views from Twin Law Cairns in the vicinity?
I would have the concerns more generally, but I've focused my response to those visualisations that have been prepared.
So there's a general concern from the council that the proposal, again, I'm not trying to put words in your mouth, I'm trying to understand so you can tell me whether this is correct or not. There's a general view from the council that the positioning of the proposal in relation to the Divington laws and the monuments, the scheduled monuments that sit on top of those hills, causes the concerns that lead you to your position, but in particular you focused on the Twin Law Cairns location because that is the particular one that is of concern to you.
That is where it is most pressing for me.
That's not the whole story, is it? Because you've got general concerns, but that is particularly illustrative of it. Okay.
We've mentioned further down Henlow as well, the likes of Bedshiel and Dunside as well. Similar.
Sorry, is that this is where I want to be absolutely clear what I'm hearing. So when you mention those other assets, are you mentioning those as positions from which you look to the Dirrington laws and you see the proposal and there is a concern? Or are you talking about them as individual assets from their own perspective, in which case we'll come on to those? I just want to make sure I've understood properly what it is you're telling me.
That is the latter of the viewpoint, the views from those cairns themselves.
And the views from those cairns to Dirrington laws, or the views
towards the proposal within the wider landscape.
Oh, right. I'm just trying to make sure that obviously I've given space in the agenda to talk about the other assets, but because I know that they're all in a small geography, I was trying to differentiate in the discussion in various pieces of evidence whether what was being talked about was the view of one set of assets and their setting when seen from others, or whether they were talking about the impact on the setting of another asset itself.
Yes.
And I was just trying to make sure that so when you refer to Henlaw and Bedshiel and Dunside, and I don't want to get into the nuts and bolts of that just yet because we're going to get into that shortly, you're talking about them in their own right, and you are, as I understand it, you're not saying to me that you're concerned about views of the Dirrington laws from Henlaw, or have I misunderstood that?
That is correct. Perhaps if we had more time, then I would be suggesting a different split between the 3 sites that are listed within your category A to the 2 in category B. So perhaps I would say in matter 4A, Dirrington Great Law, Dirrington Little Law in 4B, then it would be Henlaw, Bedshiel and Dunside.
And is it right? Okay. I note that, but I think at least to just return to what I was saying, so I make absolutely clear that I've understood. When you were mentioning Henlaw, Bedshiel and Dunside, you were talking about them in their own right rather than from the point of view of considering the settings of the Dirrington laws when viewed from them. Is that correct?
Yes, I would be looking at those more individually.
That's all. Did you want to say any more on the Dirringtons before I invite the applicant to come in?
No, I'm okay.
Okay, Mr. Trinick, Mr. McFarlane, you obviously heard the discussion there, so very happy for you to respond and respond to what you've heard and obviously put across your perspective on those matters. After you've done that, we'll see whether the council's got anything more to say, and we'll come backwards and then we'll move on. So,
yeah. Okay, I think it would just be useful just very quickly to just summarise what the factors of setting which contribute to the significance of the Dirrington cairns are. And just if you want to read it in more detail, it's presented in paragraphs 10.6.37 to 10.6.46 of Chapter 10 of the Environmental Impact Assessment Report, which was carried out in accordance with the Managing Change in the Historic Environment Setting Guidance and the EIA Handbook. So, you know, I wouldn't, in terms of the landscape position of the cairns, it's the hilltop locations of them which were intentionally chosen, possibly to emphasise the importance of the people who are buried within them, and allow those cairns to be seen from a wider landscape. They're a likely contemporary and interrelated group of cairns, so I'd agree with Mr. Elliott, views between the cairns are important for appreciating that factor. There's contextual associations with other cairns in the landscape, such as the Henlaw cairn, which is within the site boundary, and potential for associations with the Dunside Twinlaw cairns as well. Although I would stress that none of those cairns are visible when you are standing on the Dirrington laws. You can't perceive any of those other cairns. It is more just a general recognition that there may once have been a relationship between those cairns. An intervisibility with areas of possible contemporary settlement. We concluded in the Environmental Impact Assessment Report that those could have been located to the southwest, south, southeast and east of the Dirringtons, because it's from within those areas that the cairns are most, you're able to perceive them the best. So,
could you just repeat those directions for me?
Yeah, certainly. It's southwest, south, southeast and east. Yeah. So, I mean, in terms of the impact, so we've acknowledged that there would be change to the outward views looking southeast from both of the Dirrington cairns. We've concluded that it's likely that there was contemporary settlement located in that part of the landscape. So if you were to look at document number 001.269, which is the visualisation from Dirrington Great Law, and document number 001.270, which is the visualisation from Dirrington Little Law, we acknowledge that the presence of the turbines within an area which you are maybe supposed to look towards from the cairns, there would be an impact there as a result of the turbines. In terms of views towards, it was our position that there would be a degree of visual distraction when looking towards the cairns. This would be notable from locations within about 5 kilometres of the cairns. It's from within that radius that you can perceive the cairns as sort of small features on the top of the Dirrington laws. So, for example, from Langton Edge, which is document number 001.240, which is
that viewpoint?
Viewpoint 2, yep. Yeah. And from Reclue Head Hill, which is CHVP 6, and that's document number 001.273. So we acknowledge that the presence of the turbine 5 would appear in front of Dirrington Little Law in those views, so it would distract attention away from the cairn at the summit of that. So we acknowledge that in our EIAR. Similarly, when you're looking towards the cairn from the Twinlaw and the council, so for example, there wouldn't, I would disagree that there would be distraction in views between the cairns themselves. If I could point to document number 001.269, and
sorry, give me that again, please.
It's document number 001.269 and visualisation 10.5b. That shows the view.
Do you want me to look at that just now?
Yeah, can look at it just now. 10.5b. Yeah. That's it.
My apologies, it's the one that's in the box. You'll just have to give me a second.
We've got a copy here.
If anybody who's watching would like to just can just let everyone who wants to have a look just get the document up.
Yeah.
Perhaps if you can remind your colleague of the number as well when she has been able to get that.
Which one's that? Is that 269? Amy? It's 1.269.
Okay.
They're looking.
It may be that those in the public gallery just need some assistance with finding the correct document as well once that's in there, if you wouldn't mind just going and helping them look that out. So I believe we're looking for figure 10.5b. Which, if anyone's got a full suite, I assume is probably about halfway through, is it? Or towards... I'm just wondering if now might be a good time for us to take the break so that we can... we've naturally found ourselves a little delay, and I think we'll get everything sorted out and everything can be sat up. So that's just gone 11:09. Let's maybe come back at 11:25. Everyone can just get themselves... the toilets are just through there in the kitchen, so we'll take a breather just now, and then everything can be ready to go. And we'll come back at 11:25. 4, and we were dealing with the Dirrington laws. And Mr. McFarlane had just taken us to 001.269, which was that views from Dirrington Great Law. Okay, so I believe we have unboxed the public copy, so that's available if people want to follow along, and everybody else hopefully has had a chance to get the relevant copy in front of them. I've got mine down here, so over to you when you're ready.
Yeah, so now we've just referring to the visualisation, the reason I pointed towards this particular one was just in reference to the views between the Dirrington cairns. So this gives you that sense of the intervisibility between them. You can see Dirrington Little Law as a small feature at the top of Dirrington Little Law when you look south from Dirrington Great Law. And really it's just to illustrate the point that the proposed development wouldn't appear in that view, so that kind of important contextual view between the two cairns wouldn't undergo any visual change, so it would remain possible to understand and appreciate that.
So if I was standing in the place where the person who took the photograph and the produced the visualisation is standing in front of me, I would see Dirrington Little Law, and to my left, which would be to the south, is where the proposal would be in that view.
To the east, yeah, to the east, yeah, would be the proposed development. But if you were to look south with that kind of important view between the two, then that wouldn't undergo any visual change.
And that's before the break. We were talking, weren't we, about views from considering the schedule of monuments on top of the hills together. The point that you were making with this, I think you were just saying to me, was when you look towards Dirrington Little Law from Dirrington Great Law, you don't see the proposal, or if you do, it's at oblique angles. And that's the point you wanted to address with this, right? I understand that. Okay.
Yeah, and same the other way around, from looking from Little Law to Great Law. So yeah, just in terms of the other aspects of the setting of the monuments, there wouldn't be any change to outward views towards areas where contemporary settlement may have existed and from where you were potentially supposed to look towards the cairn. So, for example...
Sorry to interrupt you. So,
yeah.
I think you said to me earlier, contemporary settlement is believed to have been southwest, south, southeast or east of the proposal. Is it wrong? Of the Dirrington laws?
Yes.
So
it was...
so were I to be in a location in that direction looking towards the laws, you're saying I wouldn't see the proposal, provided it was behind me?
No, sorry, I meant in views out from the laws themselves, looking towards those part of the landscape. So, you know, the ability for you to look towards those parts of the landscape and speculate that there may have been contemporary settlement within those areas wouldn't be affected.
And is that because the proposal would be further away from where those settlements are believed to be, or because it would be in a different direction? Or
it's more just that the general presence of it wouldn't prevent a visitor from having that speculation, would be the key point. Yeah. So yeah, then in terms of views towards the general locations of other cairns in the landscape, Dunside, Twin Law and Hen Law, again the same point applies there. You can't perceive any of these cairns in outward views from the Dirrington cairns themselves. The sort of well-informed observer would potentially know that they existed in those parts of the landscape, but ultimately if looking towards those parts of the landscape, despite the presence of the turbines and the solar array, wouldn't prevent you from speculating as to the possible relationship.
One of the points that I think was raised earlier was, I think, the point that even if you can't see them, they are there and they are protected. Was what you were just saying there, did that in your opinion contradict that point or not?
No, I mean, I wouldn't dispute that if you knew that they were there, you may be able, you could draw that relationship between them. It's more just the extent to which you can actually experience that. I think the experience informs your understanding and appreciation of a monument. So ultimately, the extent to which you can or cannot see something, I think, does matter, particularly in this point. If those cairns were much better surviving, and you could clearly see them, then clearly that you get that effect of understanding that possible interrelationship between them to a much greater extent than is possible in the present day.
So is a point that you're making that the historic degradation over time of the assets themselves serves to diminish some component of how one might experience, appreciate, or understand those things, even with or without the proposal.
Yes, yeah, I would agree with that. Yeah. And just another point I'd like to move on to is the Dirrington cairns themselves. I don't consider that they are so prominent that there would be any visual competition with the proposed development, and I'm talking specifically about views from the Twin Law cairn. So again, the well-informed observer would be able to see the Dirrington cairns at the summit of the hills. But again, because it doesn't appear as such a large feature that there would be any material competition with the turbines. So, you know, document number 001.271 shows the view from Twin Law cairns.
Can we have a look at that? Because that was one of the points that I think the council was particularly concerned about. So I think it's probably worth us just having a look at it. And perhaps if you can advise members of the public, do you want to just give that reference again? Sorry, not the 00 number, the
AI figure number.
The figure number, yes.
Yeah, so it's AI figure 10.7.
10.7. And it may be that somebody from the applicant can just go and assist those who want to have a look to help them to do that. Just give me a second and I'll find mine as well.
Particularly it's figure 10.7E, which is the photo montage, which shows the view from Twin Law cairn.
Did you say 10.4?
10.7.
10.7.
Yeah, so 10.7E.
Okay, it was right at the back. There we go. Right. When you're ready.
Okay, yeah, so just drawing attention to this visualisation in terms so that the view out from Twin Law towards the Dirrington cairns, the one on the two of the two hills there on the right hand side is Dirrington Little Law. So there'll be two turbines either side of the general location of the cairn, but again, it's not a prominent feature in this view. So that's again illustrating my point that it's difficult that there would be no visual competition in the sense that there isn't really any competition to be had in that regard. You would still be able to speculate about the possible relationship between Twin Law and the Dirrington cairns, particularly Dirrington Little Law, assuming that they were contemporary. And again, we don't have any secure dating evidence for them. We're going on a sort of general theory that they were potentially contemporary.
And can I just interrupt you? So the positioning of the cairns on the summit of Dirrington Little Law, would that sit between the two turbines that are on the right-handmost side? So
Yes.
we've got the very right-handmost turbine, then we have a gap to the next turbine, and is my understanding correct that the asset sits between the two
Between
of
the
them?
two, yeah, that's right. Yeah. So I'm just drawing attention to the Historic Environment Scotland response in relation to the view, this particular view towards Dirrington Little Law cairn when viewed from twin law. So particularly paragraph 4 of page 6 of the Historic Environment Scotland response, and that's document number 002.013. So has concluded that change in one view towards Dirrington Little Law from twin law cairn is not sufficient to, and I'm quoting here, alter the ability to understand and appreciate the setting of the monument or the reasons for its location within the landscape. And that's something we would agree with as well. So ultimately our kind of conclusion is it takes into account all of the factors of setting which contribute to the significance of the monument, instead of just focusing on those which would undergo visual change. And so having that holistic assessment, you know, it was our assessment that there wouldn't be a significant impact on the integrity of these monument settings, and not a significant effect in EIA terms, which we would. So that was it for the Dirrington cairns. We could
Before we move on to Henlaw, then I'm just going to invite the council to come back and address any of the matters that you've raised, appreciating that some were before the break. So I'll let you do that, and if there's a need to respond, you can do that, and then we'll move on. Did you want to say anything about what you've heard, or address any of the points in relation to the visualisations or anything like that?
Okay. Firstly, then the mention of the cairns themselves, then managing change, the Historic Scotland guidance notes that prominence of the historic asset or place in views throughout the surrounding area, bearing in mind that the sites need not be visually prominent to have a setting. They have acknowledged in their own response the indivisibility between the various monuments, so the various cairns that we've discussed, the Little Laws, the Great Law, and the twin law cairns looking through. We differ on that sort of assessment of the specifics, but back to the early application for Inchmore, albeit different application, but there's been no change in the historic standing of things, and that specifically mentioned open views from the cairns where such views. Could
you speak a little bit more into, I'm sorry, I appreciate your reading at the same time, but it makes it difficult for us all. Could you just repeat as well what you were saying? Because I think you made a point initially about something doesn't need to be visually prominent to have a setting.
Yes.
And we just had that discussion a moment ago, so I recognise you picking up that. You were then talking about something else, and can I take you back to that, and then you can go through it. And I appreciate with everyone that the tables aren't that big, so you're kind of looking at documents at the same time as trying to speak. But the mics can flex, so if you bring it towards you in that way, everyone has the best chance of hearing. Thank you.
Where I picked up on things, the HES response does mention that there is the. I'll just find the exact link. For the Dirrington, that there is the significant adverse impact on the scheduled monument known as Dirrington Little Law became on the summit. And there,
which part of Historic Environment Scotland's response are we looking at?
That's their first page within the paragraph beneath the subtitle or advice. The proposed development will have a significant adverse impact on the scheduled monument known as Dirrington Little Law cairn on the summit of 4638.
So, this is the response that the applicant was referring to a few moments ago. Is this 002.013? This is Historic Environment, I think, was it July 2024?
It is the May 2024.
May 2024. Okay, so that's Historic Environment Scotland's response, and you're on the section which is covering Historic Environment Scotland's advice. Is that correct?
I think it's the first paragraph under our advice of that document. Yeah.
Let's just give me a moment to find that. Sorry, just bear with me a second. Has everyone been able to find that? Oh, have you been able to find that? You've located it, right? Okay. Sorry, on you go. It was Historic Environment Scotland. It was the advice part, and it was the first paragraph of that advice. Is that correct? Okay.
Yes.
Sorry, on you go.
Yes, it's
I'll allow you to
the
make the point.
first line of that paragraph there. There are further comments within. That's mentioning about the indivisibility between the various monuments as an important factor in their settings.
So you're going to have to really speak into the mic. Maybe just bring it much closer to you. It's just not picking up your voice. There we go. So go for it. Yeah.
There is the comment within those HES comments further along, that within the comments for Devington Little Law, which are in more detail, that is mentioning the indivisibility between these monuments as a substantial features in the landscape is an important part of their settings, and it gives the relationships between Devington Little Law, the nearby sites of Great Law, where there's the three cairns, and then Dunside and Twin Law cairns. Okay. Finally, there is the comment that we have from the previous Inchmore application. The open views from the cairns where such views exist are also considered a key characteristic, and the maintenance of these views is considered desirable. We've heard from Fraser about where he anticipates settlement to be in the south, the southeast and the southwest of the Derringtons. It's possible. There could be further settlements to the north that we just don't know about. The Lammer Mews are archaeologically a blank, or very blank for the amount of excavations that have taken place. Yes, there's those distractions, and that's one of the things that we differ about how much significance that is. Hence the application and its appeal.
Did you want to say any? Did you want to say any more before I let the applicant come back?
No, I think I've made my points just before that.
Okay, thank you. Mr. String, Mr. McFarlane?
Just a question before Mr. McFarlane comes in. Mr. Elliott referred to Inchmore. That's not referred to in the HES letter at all, is it? Did you refer to Inchmore?
Yeah.
Could you just clarify that?
Yes, I did refer to Inchmore. That was in my planning application response. Well,
right. So that's not. So Inchmore is not in the HES response, but it's in your own response to the authority.
Yes, moving
prior
on.
To the authority making its submission.
Yes, I did say note that I was moving on between documents there.
No, that's okay. I'm just seeking to clarify. So your reference to Inchmore was made in your submission, which was made to the planning part of the council before it submitted its response. So that's where we would find reference to that. You were reading from Historic Environment Scotland in the context of the Derrington laws. Right. Okay. So I understand what you were doing there. Okay. The applicant.
First point, just to respond to that, goes back to the reference to the managing change in the historic environment setting guidance, and the document number for that is 010.005. So Mr. Elliott quoted a section from that which said assets don't have to be prominent in order to have a setting. I'm not disputing that. I agree that it doesn't have to be prominent if everything has a setting, even if it's very poorly preserved. I think the point I was trying to make was that your ability to experience a monument and relate it to other monuments does change depending on how well it's preserved, and ultimately that does impact your understanding and appreciation, which in my opinion is experience informs understanding and appreciation. So that'd be my response to that part. Just to go on to the element, the extracts from the Historic Environment Scotland response, yes, and I acknowledge that they said there would be a significant impact on the setting of Derrington Little Law. but again, they didn't conclude that there would be a significant adverse impact on integrity. And if I could refer to page 6 of the Historic Environment Scotland response, they make a series of points about why they've come to that conclusion. If I could just read the last of these. They've said the scale of the group of monuments and variety of potential viewpoints is something they've taken into account. So by that they mean it isn't just views from one specific view, which they've considered, which is exactly the way we would do it as well. It's the holistic setting of the monuments which has been considered. So they say the expansive open ground between the 3 main cairns is over 7 kilometres from east to west and nearly 4 kilometres from north to south. So again, although the view from Twin Loch Cairns toward Dirrington Loch Cairn is undoubtedly important, there are many other viewpoints and monuments in this area from which to view the Dirrington Little Loch Cairn, its setting in the landscape and its relationship with other monuments in the vicinity. So their conclusion then is that whilst they consider there would be a significant adverse impact on the setting of the monument, in that instance, again, change to one specific view wouldn't be sufficient for them to find a significant adverse impact on the integrity of the monument setting. And we would agree with that.
Any more? No? Okay.
No, that's
so before we move on, have we said all that needs to be said on this matter? Were there any other points that you've not addressed previously that you needed to address with regard to the Dirrington laws?
No, I think we've addressed everything. We differ.
Yeah, I think the differing, a lot of it stems from a difference in approach in assessing the impacts. My reading of the Council's response was that it relied a lot on measuring the degree of visual change and equating that with magnitude of impact. And it's not been clearly articulated how that visual change would impact cultural significance through change to the setting. And again, I've pointed you towards the relevant guidance documents which have informed the EIAR, those being the Managing Change in the Historic Environment Setting Guidance and the EIA Handbook. So it's our opinion that we've followed the guidance which has been set out there, and it's not clear that the Council have done the same.
That point wasn't previously put to you, or if it was, I don't know that you necessarily had a chance to respond, so I'm happy for you to respond to that point if you wish. Otherwise, I'm happy to move on, but it's up to you.
I've also read the handbook.
Hey, can you speak into the mic again?
Sorry. I've also read the EIA handbook, and we differ on that for how much alteration, adversity, impact that there is to those settings. Therefore, what the implications are for that, for making a judgment whether I support an application, whether I'm recommending conditions or whether I'm objecting.
So your opinion is this is a matter of professional difference, in essence, in terms of a difference of professional opinion, which has led each of you to a different conclusion, in your view?
Ultimately, yes. We've got mentions further down for 7 in where I'm differing between the HES viewpoint and myself, and there is things that I could quote in how I've been thinking of the larger cultural landscape, beyond cultural heritage landscape, beyond just the formal designated part of the monument, and indeed Twin Loch Cairns is not a designated monument itself, but one of value.
Okay, so I think sorry, we're getting a little bit of feedback. I take it that, yeah, I think I understood what you're saying. You take the difference between you both to be one of professional point of view. I took what you were saying to be that, and that you feel the assessment you've carried out has been done in a way which is different perhaps from that of the council. Is that a fair understanding?
Yeah, I think, apologies. Yeah, and I think the result of that, there's been an overstatement of the magnitude of impact as a result of the approach that I felt the council had taken.
But certainly professional opinion difference comes into it, but there's from your point of view there's two differences, from your point of view there appears to be one difference. Is that a fair recognition of what both of you are saying you might not agree with each other, but that is the distinction, at least. That's the distinction I think I am hearing. Is that what you're telling me?
Yes.
Yeah.
Just to add to that, it's not simply a professional point that's being made. Historic Environment Scotland published Managing Change Advice on Setting, specifically so as to guide practitioners through stages 1, 2 and 3 of the assessment. And the EIA report followed those stages explicitly. We do not see the same attention given in the response of Mr. Elliott. That is the point we're making.
That was the point that I was picking up in terms of my methodological comments. So that was plain from your submission. So I understood that, and I understand where the distinction lies. Okay, if no one's got any more on that, I'd like to move on to hen law. And I'll invite the council again to go first this time. So just as a reminder, hen law cairn, 1550 metres west-northwest of Langton Lees, SM4548, which hopefully that one is the correct reference. Please explain the nature of the dispute as you see it and why your respective position offers the most plausible conclusion for Scottish ministers to reach. So I'll invite Mr. Elliott to go on this one.
Again, we've said before of my background and how I'm seeing the cairns both collectively and individually with their shared viewpoints and how they are using the landscapes. So in this case, hen law is just situated closer to the development area. Also, it has a similar viewpoint in that it is on the edge of the hill rather than the very top of hen law itself. It is akin to the monuments that I've highlighted of Northumberland interest again, where you're overlooking further monuments. We've had the anticipation from Mr. McFarlane about where he is seeing the settlements to the southeast and the southwest of the Downton themselves, so all the more likely to be viewing the hen law site. There is the shared characteristics between the hen law cairn and others that we've already discussed and to discuss, which I've seen in commonality with other sites. So I've mentioned those ones in Northumberland. That was in the Cultural Heritage Statement 4.1.2 paragraph.
Could you just repeat that reference for me? Sorry, I didn't catch that.
It was the one that we were referring to before. That was thought parallel, and I'll just call it what we will, for comparisons in my cultural heritage within the statement or in respect of viewing session 1, under the title Scope of Evidence 4.1, and then the larger paragraph number 2.
Just so I've understood that properly, your discussion that you have in 4.1 section 2 of your hearing statement, where you refer to other locations as, I think you used the word parallel, is that what you're referring me to just now?
Yes,
okay.
There are those shared characteristics between those various monuments and the ones that are potentially impacted by this development.
And just to clarify again, I think when we were talking about it earlier, we did clarify, and it was, you were not saying that those Northumberland assets in this instance, which are referenced here, are affected by the proposal in the same way as hen law. You are likening the way that they relate to each other, the way that hen law relates to other things. Is that a fair understanding of what you were saying?
Yes, they are similar monuments, but they are not going to be impacted by this development.
So you're using them as a basis to, you're using them as a reference point to help somebody understand a similar or equivalent relationship elsewhere between monuments, as
yes,
is the case between this particular one, hen law, and some others.
Yes, they are similar monuments of that ilk. There are other examples that I could pick again elsewhere.
So, yeah, sorry, if you want to continue with what you can.
So, as I've said, that similarity of monument and also the similarity of the likes of overview chapter that Pete Topping did for the Neolithic landscapes, which I've provided.
Can I just interrupt you a second? Because I think, as I understand it, you seem to be, in order to explain your views on Hen law, you appear to be giving me a series of other places which you argue to have characteristics which are similar or not dissimilar to that. What would perhaps be helpful is if you can just explain the issues in relation to Hen law itself, because I'm just thinking I would have to have a contextual understanding of these parallel assets that you've given to me, and it would be helpful just to understand Hen law, because I suspect I have an equal understanding of both of them, which may not be where yours is. So perhaps if you can just tell me the issues in relation to Hen law itself, and that would really assist me.
Hen law is one of the similar monuments to those ones, so
It's the factors that I'm looking for, the factors that lead you to your conclusion that you feel differ from the applicant's points.
there are the similarities of landscape. We differ again on that significance of how much we feel that is impacted. We've said about the viewpoint location of the Henlow cairn and why it's located where it is, so it can be visible from the likes of the settlements that are hypothesised below, as well as the location to be visible, so there is the views both looking towards and looking from the cairn that equally are shared by the likes of Bedshiel and Dunside further along on that plateau.
Okay, I want to come to those assets a bit later. I take your point that you're viewing it as a kind of as a collective, or at least I think that's what you're saying to me. You mentioned the point that the monument itself doesn't sit right on top of the hill; it sits a little lower. And did I understand you were saying it faces towards the Merse in that direction? So southeast, southwest, that it looks in that direction, and your hypothesis is that the settlements that Mr. McFarlane was referring to, it would have been positioned so that it could be seen, and it could be seen from those, and you could have views of those from it by your understanding. And is that, have I correctly understood what you're saying?
Yes, it is on that false crest edge on the southeastern side of the Henlow itself. It's not the very top.
And you see that as being deliberate for the purposes that I've rehearsed with you just there?
Yes.
And therefore, can you just outline for me your concern about the proposal? Is it the positioning of the proposal and in relation to the where the settlement area might have been or is suspected to have been?
The concern for Henlow in particular is of one of the sort of views to that sort of wider landscape. It is so close to the development that it might have ancillary things that we just don't know about below ground. So it could be the likes of pits, graves, the likes of surface scatters that have been covered by vegetation, time, soil, that we're just not seeing.
And those would be unknown assets, would they? Or are they known assets that are just not designated?
They would be unknown at this time.
So you're pointing out there, I suppose, something that we talked earlier. I know conditions are coming on Friday, but we talked earlier, didn't we, about a condition that would cover archaeological investigation, and presumably in any instance with anything, if you don't know something is there, you can speculate that it may be there because there may be knowledge that points you to that, but obviously the condition, it's the intervisibility is between Henlaw and those others. Is that a factor in amongst your concerns as well?
I believe that they would be indivisible. I'd need to have a further check of that, but they are that similar landscape.
It might be that I've misunderstood what you were saying, so I'm happy for you to clarify.
I'd need to check on the invisibility of those cairns themselves, but I believe that they would be, and they are in that similar landscape position along that Lammermuir edge.
Yeah, I just wanted to make sure I wanted to make sure I understood the factors that were of concern to you, and I'd taken it from what you were saying that the positioning of the asset, on the Henlaw asset, in relation to where a settlement is suspected to be, and therefore the proposed presence of the proposed development in that space was a concern to you. And you happened to mention the others, and I was trying to understand whether intervisibility of other assets with Henlaw was also part of the concern, or whether that was a lesser issue.
It would be a concern.
But is it or is it not part of your objection?
It is part of my objection, but I would acknowledge that it's of lesser concern in that gradation, as it were.
So the main concern is the first one. It's the relationship between the possible location of the settlement and Henlaw itself. Is that, have I understood that properly?
It would be in the sort of gradation from the Divingtons and Twinlaw, working through that next stage, as it were, through again.
Okay, and were there any other matters? Because I've interjected a few times and interrupted you, so just want to make sure that there were any other issues that you wanted to deal with before I bring the applicant in.
I'm okay, thank you.
So I'll invite the applicant to come in on the points that have been made.
Mr. McFarlane will deal with deal with most of it. There's two preliminary points. We're coming back again to direct impacts, and so on page 4 of document 13.5 is where Mr. Elliott outlines his concerns about the construction of the turbines and what there might be underground. I just remind the council again that it's been firmly agreed direct impacts are not part of that case. They've confirmed that this morning. The second point just to make is that I am concerned about where paragraph 412 of the council's case goes. It's the only information we've got on wider context or associations, being the point that Mr. Elliott is making. But unless you're going to be invited to visit this wider context and to evaluate its commonalities with what is going on around this site, I'm not sure where that evidence goes apart from nowhere. It's simply been dropped into the hearing statement. References to Weatherhill, Hare Cairn, Black Stitchel. You know, there's been no further evidence on this. We've not been provided with any detailed evidence beyond that one paragraph as to why this is relevant to the lease sale inquiry. You've not been invited to visit these sites, and even if you did, I think we would have something to say about that. So we have no means of evaluating whatever similarities Mr. Elliott sees of contended relevance to the lease sale inquiry. That point is a forewarning of what we're coming in closing as well.
I'll let Mr. McFarlane deal with all the other points, and then you can address all of those if there's anything you need to say in response, and then we'll carry on. So.
Yeah, so for, and now what I would say is that the cairn as it survives is about 25 centimetres in height. It only survives to that level of again, that's the extent to which it survives. It's only appreciable from within a range of about 40 metres. So even accepting that, you know, views from the south were important, and that's the location where the turbines would be positioned, you actually have to go quite considerably outside from where the turbines actually are in order to actually look towards the cairn from the south. So in that sense, there wouldn't really be any significant impact on that particular aspect of its setting. We have acknowledged that views out from the cairn looking back towards that part of the landscape may have been important, again on the basis that that may have been where the people who built the cairn lived and where they settled. And we've acknowledged there would be an impact through some visual distraction towards your ability to look towards that part of the landscape and speculate that that may have been where there was contemporary settlement. I would say that the other factor of setting is the likely relationship between Henlaw and the Dirrington cairns. Again, they're potentially contemporary monuments funerary monuments, but there wouldn't be any interruption in views from the cairn looking towards the Dirrington cairns. And again, if you're talking about in combination views of Henlaw and the Dirrington cairns, you could only get that in combination view from within a range of about 40 metres, and so there wouldn't be any interruption to that as a result of the turbines. Just pointing to, regarding visibility of other cairns, I didn't quite pick up which ones Mr. Elliott was referring to. I think it was Bedshiel, Dunside and Twinlaw, the ones I inferred from that. None of those cairns are visible from Henlaw. And in any case, they're to the west of the turbines, and there wouldn't be any interruption towards the general views towards those parts of the landscape. So again, there wouldn't be any impact on that element. I just want to point to Historic Environment Scotland's response again. So that was document number 002.013. So in their response, Historic Environment Scotland acknowledged that the cairn is a low-lying and not distinctive landscape feature. They consider the main aspects of its setting is its relationship to the Dirrington cairns on the high ground to the west. And they ultimately conclude that despite the proximity of the turbines, the proposed development to the cairn, that this wouldn't impact the ability to understand and appreciate the relationship between the monument and those cairns and the laws, and they agree with the conclusion in the EIAR that there would be a minor adverse effect on the setting of this monument in EIA terms, which wouldn't be significant, and there would be no significant adverse impact on integrity on that basis. So yeah, that's largely it. I think, and again, it goes back to the a measurement of visual change to the setting of a monument shouldn't be directly equated with adverse impact, and I think this is an example of that. That's everything. Thanks.
Okay, I'll let the council come back, because I think there was Mr. McFarlane's points in general. Mr. Trinick raised 2 points, because I know we discussed the matter of direct impacts earlier. I note Mr. Trinick's point there, but I think you were telling me earlier it wasn't part of your objection. I don't think you mentioned direct impacts when you were just speaking a few moments ago, but I'll let you address it if you want to. You can clarify whether I'm correct in my understanding. There was Mr. Trinick's point as well, and I think it was one that I was asking you about, where in paragraph 4.1, section 2, you made analogies to other assets that are elsewhere, but I think I was saying to you I would have to understand them in order to understand the context you want me to take from it. So it was perhaps more helpful for you to just do what you did, which was talk me through Henlaw, but I'll allow you to respond to that. And then there were the points that Mr. McFarlane made, so if you want to respond to any of those, you're welcome to do that.
Of the 4.1 and 2, then from my background in Northumberland and ATR matters, then that has been looking at monuments irrespective of planning applications and pumped of whatever sort, and to see those commonalities of locations. I would agree it would be useful for you to see those monuments to compare and contrast the likes of Henlaw cairns with that.
Is it something that you have provided visual evidence on? I'm trying to think whether I'd seen anything. Has the council submitted anything to that effect? No. So there's nothing that I can go and look at that will allow me to, besides what you've written here, there's nothing else I can go and look at.
There is the publication that I referred to for the Neolithic landscapes chapter, which has the illustration of the cairns locations.
And whereabouts is that something that is submitted? Where would I find that?
I would just say it was submitted with his hearing statement. He had a schedule of documents. They all had the suffix CD0 and then a list of documents, and these included the Northumberland viewpoints he's referring to.
When you refer to the CD document, the CD, are those the ones that were referenced CD in the hearing statement?
Yeah.
Right, and I think I understood that most of those had been submitted with the exception of the ones that I asked to be submitted separately.
And they were submitted towards the end of last week.
So which one of these is the one that, is it the K. Elliott response to the original planning application of 23rd of January 2025 CD003? Is that the one that has the Neolithic analysis in that you're referring me to?
That has reference to that document.
But not the document itself?
That's sent on the document. So from my record, I have it as CD01. Bear with me 1 second.
That's okay, just take your time to find it.
So document CD.
Sorry.
I first want to make sure the council knows which document it is from its own list, and then we can see whether we can locate it in the actual document list. I'm at the moment I'm just seeking to understand whether the material that you're referring to me is something that has been submitted to the inquiry, and therefore that I've got it and people have been able to see it.
The document Mr. Elliott is referencing is not part of the documents before yourself today.
So
As far as I can find, it is a Neolithic landscapes document, and it does not appear that this was submitted as part alongside Mr. Elliott's hearing statement. Perhaps it should have been, which makes that my error. But certainly, whilst Mr. Elliott has referenced it, we have not submitted it.
right, so the document that has been submitted is Mr. Elliott's response to the planning team,
Yeah.
which itself refers to the Neolithic document that he's referencing, but that document has not been submitted, so it's, the applicant hasn't had a chance to see it. I've not had a chance.
No.
To, right, okay. In any event, the point that's being made is that parallels are being made between those things. So, this, is it fair for me to see this matter of itself is not a matter that forms part of the council's objection? Is that a correct understanding, or is it, or does it?
It is background to why I am thinking the way that I am thinking, rather than being the reason for the objection itself.
Right, it's part of the rationale. Right, okay.
I feel it's contextual to Mr. Elliott's the point of objection in relation to this, rather than being a direct objection itself. It provides wider context to how Mr. Elliott has reached his position. I think I've understood that correctly.
Right. But okay, I think I understand what the basis of it is, but nevertheless I don't have it, do I? And the applicant hasn't seen it, and nobody else has seen it. Okay. Do you want to take me through then the other matters in response to the applicant's points?
Okay, if you would like to go through which ones you would like to start off with.
So we've got that point on the Neolithic matters, accepting the discussion we've just had. There was the we've dealt with, haven't we? So there's the direct impacts point, which I'd understood that you dealt with earlier, but I'm happy for you to address that again. And then there were Mr. McFarlane's points of professional difference, I suppose, in your differing opinions on the matters to do with Henlot. So I'm happy for you to respond to any of those that you want to.
Okay, on the direct impacts, then yes, it has been agreed by Sarah and across the way for the likely condition. That is.
Can you just make sure you're speaking to the mic? Thanks.
Sorry, that is in the likelihood of conditions being applied. So yes, I would be happy with those conditions for those direct impacts, but you will be having those indirect impacts, as we've mentioned, for settings. And yes, similarly, we differ on that magnitude of what we are seeing for that larger cultural heritage landscape beyond the likes of the designations themselves. So taking that broader view of the historic landscape, the designation is part of that, but as we've said before, the prominency or lack of prominency of the monuments themselves is neither here nor there. It is that the monument is there in the locations. I've said about the parallels, and we've just bashed about those of other examples, and for why I'm seeing that commonality. So again, we differ. That's the professional differences.
Did you want to say any more before I invite the applicant to come back on that?
I don't think I do. Thank you.
Okay, thank you. I'll have you address any points raised out of that if you've got any additional ones you want to make. Right. Let's just see where we are. I was going to break for lunch at about 1. That gives us 40 minutes to do possibly Bed Shield and then come on to Dunstan. We've got two choices. I'm relaxed either way. We can either take an early lunch and come back and then do part B and the remainder of the agenda, or we can try and get on with part B just now and try and break about 1. What do people fancy? Mr. Trinick?
I'd like to crack on.
Was Thompson the same?
Yes.
Let's do that then. Right, so let's move to section B then, and when we get to the end of this section, I'll allow the applicant to sum up. So, what factors persuade the parties that their relative positions are correct for the settings of, firstly, Bed Shield Cairn 950 NNE of SM 4630, and then Dunside Hill Cairn 1225 metres south of Baiercleuch, I'm happy to have my pronunciations corrected, SM 12507. So we'll do these in turn, and I'll invite the council to discuss its position first of all. Same emphasis, we're looking for the differences between you. So if we can do Bed Shield first, over to the council.
These are similar monuments that we've already discussed. They are more individual in character. They are located on the hill slopes leading up to the higher Lammermuir edge and towards the higher ground. I hesitate to say towards the Dimmingtons. For specific. They share.
Right, can you speak into the mic?
Sorry,
I know you're reading, and you're kind of maybe if you position what you're reading into where the mic is, then that might assist you.
I've said of the sort of shared characteristics of the various monuments. So these are in similar rising ground with.
I'm sorry, are you talking about both together? Are you talking about both assets, or are you talking about Bed Shield on its own?
I'm talking about both of them together again.
Is that necessary? I'm happy for you to do that if it's necessary with the context that you need to set
That's the
forward.
way that I'm seeing them together.
Okay, we'll do that.
There is slight differences between them, as we've said before. For the likes of Henlow, that might be something that would have been joining this lower group, as it were, rather than the very high tops of the Derringtons. But again, there are those similarities in that they are on rising ground, rising from the south to the north. The development proposed is in the lower grounds of those that has been hypothesised for settlements already in the southeast and southwest of the Derringtons. These have similar characteristics, as we said, to the other cairns in that they are having views to the lower ground beneath them, albeit they aren't prominent monuments as themselves in either their upstanding remains or as their locations as prominent as the Derringtons, both Great and Little Low. They are all recorded are scheduled monument, and again there's been no change since the Inchmore application in how those monuments have been graded, so they are nationally significant and attention of HES, whilst not to the whole national
near the top perhaps, but does that suggest then that the significance was, and because you've mentioned potential of nearby settlements, the fact that they're not on the top and that they're lower down, does that emphasise a link between the settlement and the asset, or the alleged settlement, I suppose, because we don't necessarily know whether there was one or where it was, but does that then emphasise that relationship rather than perhaps a kind of I'm on the top of the hill, look at me from everywhere around type of relationship? I'm sorry, that's not very good cultural heritage language, but I'm just wondering whether there appears to be a distinction between an asset that is positioned as these are in relation to settlement versus those that might be on the top of something and are perhaps, would they be designed to be seen by everybody from everywhere, whereas those on a slope are particularly related to the settlement in question? It's just something that occurred to me when you were discussing these. It did a little bit with Hen Law, but you mentioning it again has prompted it in my mind, so I was wondering whether that was your take on it.
There would be some sort of distinction, admittedly, but we don't know what the basis of that distinction is. Perhaps football analogy, Crystal Palace is a football team and so is a Macclesfield Town.
Fair enough, okay.
They play with different resources, they have different materials.
No, that's fine. That answers my question. So, I mean, and in your view, the point of difference between you on these matters, can you just tell me a little bit about what you think that in terms of the actual effects that the proposal would have and your concerns about that?
I'd have concerns that the proposed turbines and solar arrays are all the more visible from these locations, where we've discussed them from the Derrington side of things, then that's been at more of a distance. Twin Low Cairns are getting more of a distance again, so that would be towards more of the turbines as impact, but this is more of the turbines and the solar panels themselves.
And is the impact that you're concerned about, is that in views of the assets from other places that are seen with the proposal? Or is that views out from the assets and the proposal is in them, or is it both or something else?
This is more views outwards from those assets toward.
Sorry, did you want to say any more?
I don't.
And I've no doubt the applicant is going to ask you this question, but sorry, they won't be asking this question because there's not an inquiry, but it's a hearing. But I've no doubt they'll make the point because they did make it in their statement. Bed shield cairn wasn't scoped into the EIA, was it? And did the council ask for it to be scoped into the EIA?
I would need to check on that.
My query is because in reading through the material there seemed to be, and the applicant seemed to be directing me towards it, so I need to ask you, that you appeared to be bringing bed shield into matters. I'm happy to be corrected if I've misunderstood, but that bed shield cairn, although it's a scheduled monument, was not one that was covered by the assessment. Is that your understanding? Have I misdirected myself with that?
I would need to reread the chapter, but I don't think it occurred within the immediate thoughts to the planning application.
Sorry, can you say that again?
I don't think it occurred in my immediate thoughts to the planning application. I was more concerned with those in nearer proximity of the Henlow and the views from the Divingtons and the Twinlow.
Okay, I'm going to invite the applicant to come back. Do you want to say any more before I do that? No. Okay.
Just to, I can help with that point that was just raised just a moment ago. So referring to document number 001.157, page 19, which is the scoping opinion provided by the council, which was provided on 8th of September 2022. They laid out which heritage assets they considered would require consideration for indirect impacts, or as we've understood, impacts on setting, but bed shield cairn wasn't included in that.
And it's not in the assessment, is it?
It's not. So on that basis, we didn't assess it, and Historic Environment Scotland didn't ask us to assess it either.
Because I think Historic Environment Scotland listed a series of assets, didn't they, in their responses on the 8th of September and the 28th of August as well, 2023. And it wasn't on the list of ones that they were asking for. I think they did say in their earlier response in September 2022 that list wasn't exhaustive, but nevertheless, it isn't one that you include in the assessment, is it?
No. We submitted a technical appendix, 10.1, which included a stage 1 setting assessment. Document number for that is 001.159. So we submitted that, and that is a preliminary assessment which identifies assets which we consider require further assessment in detail in the EIA. And again, we concluded in that assessment, as part of that assessment, that although there would be visibility of the proposed development, we didn't consider that would constitute an adverse impact on its setting or its cultural significance.
I think I've got that document in front of me. Is that Environmental Impact Assessment Report, Technical Appendix 10.1?
Yes.
Okay, and so could you direct me to the part of it? Is there part of that deals with the asset in particular, or is it?
No, it's dealt with as a general. We list in the technical appendix, we list all of the assets which we consider should be taken forward for further assessment in the EIAR, and then any others not mentioned in that list, we have mentioned the reasons why. For that, if you give me a moment, I can find the paragraph number.
I mean, that's okay. So
Okay.
that was the purpose of this. And
Yep.
would some of the scoping comments made by Historic Environment Scotland, for instance, and the council have come before and after the publication of this document, or after?
Yes, I'm not sure on the exact order, but it's possible it could have been that document could have been submitted after, but we would have submitted it before.
They would have seen a draft version, for instance.
I believe they would have. Yeah,
I think I've just seen on the front of the document it says 12th of December 2023, so that would seem to post-date the scoping comments that I'd mentioned. But
okay.
I've got scoping comments, haven't I? They've been submitted to me from all parties, and I've got it.
I think it was really more just a point that I mentioned that more just to say that it had been considered as part of that work. Although it wasn't brought forward into the EIA, it was considered there, and there was opportunity before that for it to be requested to be included.
Sorry, do you want to continue with the other things that you?
Yes, so I could just start with bed shield cairn. Again, Historic Environment Scotland didn't mention this monument or Dunside Hill cairn, actually, for that matter, in their response to the development. So they didn't consider there to be any impact on the setting of these monuments as a result of the proposed development. In terms of bed shield cairn, I just want to mention that it's not positioned in a prominent location. It's actually on the lower slopes of Dirrington Little Law cairn, closer to the low ground, so that it doesn't have the same landscape position as the other monuments in question, in the sense that it is not as elevated. It is in a lower part of the landscape. Again, it goes back to the same sort of methodological issues we mentioned earlier on. A lot of the council's case relies on explaining that there would be change to views, and that there would be the introduction of visibility of turbines in views from these monuments, but there's no articulation as to how that impacts cultural significance or impacts your ability to understand and appreciate the asset. So, and on the base, just following on from that, bed shield cairn, when we carried out our site visits, actually it's suffered quite a lot of damage recently, to the point where it's quite difficult to actually identify it as a monument. So again, that impacts your ability to relate that to the wider landscape. And pointing to paragraph.
And just on that, I think you'd mentioned, did I read in your statement you were saying there's some signs of historic quarrying in the vicinity of the asset? I think when I was going up Dirrington Little, or it would have been Dirrington Little, yes, Dirrington Little, or I think I could see the quarrying, or the remains, I suppose, of the quarry. It's not active, I don't think, or it didn't seem to be on the day I was there. And I wasn't specifically directed at that stage, I don't think, to this asset, but I was aware from your mapping that it was there. It would be positioned around about the location of the quarrying. Is that fair?
Yeah.
So the quarrying hasn't destroyed the asset, but the quarrying is around the asset. Is that?
I mean, I haven't investigated thoroughly, but it does appear to have destroyed quite a lot of the cairn. And that's in paragraph 125 of our hearing statement, the mention of the recent quarrying activities.
Sorry, I interrupted you when you were about to say something else, so just take a moment to get yourself back to where you were, and then when you're ready.
Yes, certainly. So again, it's similar kind of, we return to the similar arguments we've had before. Again, we wouldn't agree that just simple visibility of the wind farm in outward views from this monument, assuming it even survives, would materially impact your ability to understand and appreciate it as possibly an early Bronze Age funerary monument. You would still be able to relate it to the nearby area which was likely settled, and you would still have that likely visual link to the Dirrington cairns. Presumably this cairn was positioned at on the lower slopes of Dirrington Little Law in order to look towards those cairns on the higher ground to the north. There would be no interruption of that view at all. For Dunside Hill, we return to a similar viewpoint, a similar argument as previously. This Dunside Hill cairn is on an elevated part of the landscape.
Sorry to interrupt you. Am I correct? Dunside Hill is further north than Twinlaw Cairns.
Yes.
Is that people's understanding? So
that's correct.
I don't know if it's a ridge beyond or what have you.
Yeah, there's a kind of. You're right. There's a kind of a sort of slight ravines, maybe not the right word, but yeah, there's a dip in the landscape to the south from Dunside, and then up from that is Twinlaw Cairn. That's right. In terms of Dunside Hill cairn, I mean, it's the same factors as setting we've mentioned before. It's the elevated position, the views towards contemporary settlement, the possible relationship with other cairns in the landscape. Again, there's not really been any articulation from the council as to how the development would prevent your understanding and appreciation of those factors of its setting. And really the analysis given, it seems to focus more on the view to Dirrington Great Law instead of actual impacts on Dunside Hill Cairn itself. Now, in terms of that visual relationship to Dunside Hill,
Sorry, can I interrupt you there? Just you said the analysis appears to focus on the view to Dirrington Great Law. Is that your own analysis, or that, in your opinion, of the council?
I mean, it was written in their statement. They specifically mentioned the view to Dirrington Great Law from Dunside Hill. So you can see that in document number 001.272, which is AI figure 10.8, which shows the outward view from Dunside Hill. It might be useful just to quickly look at it.
Just remind me of that reference.
001.
I'm sorry, no, the figure reference.
Figure number, sorry, 10.8.
10.8. And was it 10.8A or B? Or? So if anybody in the public gallery wants to look along, we're probably just a few pages along from where you were last open.
I think I thought montage from this. So.
And we're looking at
10.8A.
Figure 10.8A. So just let everybody find that. And this is a wire line.
It is, yeah, with the photo.
So rather than a photograph, this one's a wire line. Figure 10.8A, entitled Cultural Heritage Viewpoint 5. Okay, I think those who want to look have seen that. So do you want to just tell us what we're looking at first and then take us through the points you want to take us through?
Yeah, so this is the outward view from Dunside Hill Cairn, looking towards the two Dirrington laws. You can see them as the hill forms. We are about, the distance to the nearest turbine is 9.4 kilometres. So once you get to this sort of distance, obviously your ability to experience the cairns at the top of the Dirringtons diminishes quite considerably. Now, Dirrington Great Law Cairn would have one turbine peering above the landform itself. It would be offset from the location of the actual cairns, and at that range the cairns are difficult to perceive in any case.
And would I be correct that the three cairns on top of Dirrington Great Law, they are on the summit, or at least they congregate around the summit? Is that fair?
That's right, yeah.
And I can see with the text there, we can see Dirrington Little Law to the right, so we've got Lees Hill in red, which is the proposal, so we can see the 6 turbines there. We can see one of them cresting not the summit, but shall we say one of the the higher parts of the hill. And then to the right, it appears that Dirrington Little Law, the summit of that actually sits below the horizon. Is that correct?
Yeah, it's hard to see, yeah. And actually, in reality, when you're at the cairn, the landform appears slightly higher. So the cairns, the actual hills themselves are more difficult to perceive than is suggested on the wireline. It's just a element of the modelling. So.
And sorry, your point here was that about intervisibility.
Yeah, so the point I was making was that over this distance, the cairns at the top of Dirrington Great Law are hard to see, and ultimately the presence of the turbine there wouldn't prevent you from speculating as to the possible relationship between the two cairns. And also, views in all other directions from the cairns would undergo no change, and you would still be able to understand and appreciate the possible relationship with contemporary settlement lower down in the landscape, and potentially, if there was a relationship with the twin law cairn to the south. And
you mentioned settlement in relation to this particular asset. Am I right? The foreground on this wireline looks relatively flat. Is that the crest of the hill upon which it sits? I recall from my trip there was a dip behind because it helped me to cycle rather quickly back up the hill again on the other side. But so what we're seeing where this kind of expanse of white is, there's a line, and the red turbines of Lees Hill, some of which appear to be kind of cut off at the bottom by that line, but that line isn't the ground on which they stand. That is the crest of the hill, and they stand on ground that's much further behind that. It's just the viewing angle from here.
Yeah, Yeah.
Right. Okay, that's helpful to understand. So where would the settlement have been, or is alleged or thought to have been, or if we know or don't know?
We don't know, unfortunately. It's possible, given that it was on a high point of the landscape, it's possible that it was in much lower parts of the landscape where they erected the monument to be in an elevated position, so that from where they lived they were able to look up towards where their ancestors were buried, for example. So it's possible that from that, from the lower elevations off the hill itself, it could have been where the settlement existed. So the intervisibility between the two parts of the landscape.
And if that was the case, given excuse me, given the landform that I'm looking at, and the fact that this isn't on the summit of the hill, would that settlement possibly have been to the left or to the right of this, or would it have been kind of over the hill? It just the viewing angle from here doesn't look like you can see into the dip. So I'm just, if that relationship was to have existed, might it place the settlement? I'm asking you to speculate as a cultural heritage professional where that might be.
I mean, it's not impossible that it existed on the hill itself. Conditions were different in the Bronze Age. In terms of conditions were less boggy. It's possible to have settlement in more elevated parts of the landscape. If I had to hang my hat on it, I would say it was more likely to have been in the lower parts of the landscape, downslope, from where you would have looked out from this cairn towards those parts of the landscape, and likewise back up towards the elevated part of the landscape where your ancestors were buried.
But there's perhaps speculation, but there's no actual evidence of where that was.
Yes, absolutely. Yeah.
Sorry, if you want to continue.
That largely concludes my my comments on Scottish Border bed shield. I would say is that we in the EIAR we concluded no impact on the monument. That's in paragraph 10.6.78 for Dunside of chapter 10 of the EIAR. So we found no impact.
Sorry, yes, you said bed shield initially, but you meant Dunside.
Apologies, yes.
My brain was working slightly slower at that moment, but
Dunside,
yes, I understand, yes, because you talked about bed shield before.
Yes,
right,
apologies.
No, I understand which one you're talking about. Right, that's fine. Did you need to make any more points before I invite the council to respond?
No.
Okay, so Mr. Elliott and the council, you have heard the alternative position of the applicant on those different matters. Was there anything that you wanted to respond on?
Looking at my planning application response, then I did mention both Bedshiel and Dunside as fringe cairn, hill cairns, with sharing the broad landscape and seeing those as concerns with distraction to the visitor. Sorry, the distraction to the visitor of the wind turbines that would be encountered from those views. Though, as I've said just before Mr. McFarlane's comments there, then in the sort of gradation, they're not as significant for objection. It is more that those Twinlow cairns, Dirringtons and Henlow, though disliking the views from Bedshiel and Dunside, then I'd agree that it wouldn't be as objectionable if it were just those two sites on their own.
So that I understand, then you're referring me to the response of the 23rd of January, which you made to the planning department prior to them issuing their response, and you're saying that in that response you made reference to Bedshiel and Dunside Hill. Is that, first of all, is that what you're saying to me?
I did mention both of those.
And secondly, you mentioned there that the focus of your objection is on Dirringtons, Henlaw and Twinlaw cairns, and less so on these two. Did I understand what you were saying properly?
Yes, that would be my way that I've graded things in the order of their appearance and the wording that I've used in both the comments of those other cairns to these pairs.
So, are you so that I've understood this properly, one, are you disagreeing with the applicant's scoping out of bed shield. 2, are you disagreeing with anything that Mr McFarlane has said in terms of his analysis of these two assets in general, and in particular what the EIA says about them? And therefore, does your position that you've outlined in your 23rd of January response, that didn't find its way into the council's objection, or at least it didn't appear to be part of the council's objection, even if it informed it? Can you just clarify for me what's the case on those matters?
On the case of the being in the scoping, then as I say, I've mentioned them in my initial response on the analysis, then yes, I suppose that they're not as damaging within the grander scheme of things to the Derringtons and Twin Law Cairns side of things, but they are still distracting nonetheless. And of that sort of grading, as I say, then leading, as it were, with through my argument for those Twin Law Cairns, the Derringtons and Henlaw, working through of other things, their sort of fringes that I'll put there at the bottom would be of particular concern, being liable to be deemed distracting to the visitor.
Can you just repeat that last bit? I just wasn't clear what you were saying.
2.5 wells not overtopping Derrington Great Law Cairns would be of...
Sorry, are you quoting from a document?
Yes,
Which one are you quoting
planning
from,
application response.
that is the 23rd of January response, is it?
Yes.
Okay, right. And which paragraph of that?
It is the one that's titled Dunside Hill Cairn.
Dunside Hill Cairn. Right, sorry, and you're quoting from that, so on you go.
And in the end portions of that, 2.5 wells not overtopping Derrington Great Law Cairns would be a particular concern, being liable to be distracting to the visitor, not to mention detrimental to their experience and understanding of the site. You're going to be having something great, large, incongruous as a turbine. That's certainly going to be giving you some sort of experience for the understanding of the site. Not everybody has that archaeological specialism to have a look at these sites. You may understand the site, but it's not necessarily helping your experience, and it's not necessarily giving anything to your appreciation of that site.
Okay. Did you want to say any more on that before or on any other the matters that were addressed by the applicant before I invite the applicant to come back?
Nope.
No? Okay. Did you want to respond to any of those first, and then if there's any other issues, we'll deal with them. If not, I'll let you close.
No response from Mr McFarlane, just a question from me. Okay. Do I understand the council's position then to be that had the only two cairns in play been Bedshiel and Dunside, no objection would be made on the basis of impacts on those cairns? That's what I sort of understood to be said. They were a contributor to the case, but of themselves they were not objectionable.
Yes, you can take a moment to discuss. I think I'd like to know the answer to that question, because it would at least help me understand whether they were part of what framed your wider objection. Because what I was trying to understand was if you'd mentioned them in context in your response to the planning department, but they hadn't found their way to appear as forming part of your objection, is what Mr Trinick says therefore the case, or is there something else we need to understand?
From my point of view, then if it had been just those cairns, then impactful, probably not to objection side of things, but that is just my viewpoint. There are other consultees within the council.
Do you want to say any more?
I think Mr Elliott has correctly surmised the position there. So that if those two cairns alone would not necessarily have been enough to substantiate a full objection, given that they are not named in which I think it's point 5 is the objection, particularly in relation to archaeological impacts. They are not named there. and how Mr. Elliott has outlined that there are impacts, but those alone, but were not for other matters.
And the focus of your objection was the other factors that you mentioned. Sorry, you wanted to come in?
Yeah, I think in my reasons for objection at number 5, we referred to the prehistoric cairns as a whole, and that fell within them. But like Sarah has said, that if you were individually looking at them, just those two, then yeah, there wouldn't be a reason for objection.
So your reference to prehistoric cairns in that document of 31st of March 2025, that was the council's response. Its reference to prehistoric cairns should be taken to mean everything that's covered by the EIA plus the ones that we've just talked about.
Yes.
And it's that context which focuses your objection on the points that you identify. And the thing you seem to be saying is, yes, had these two been on their own, then it wouldn't have been sufficient to. Okay. Did you want to say any more before I let the applicant come back? No? Okay, right. Mr. Trinick, Mr. McFarlane, you can have a minute if you want, but...
It's just I want to clearly understand the scope of the council's case and how that case is made up. We know that we have objections on the basis of impacts on Derrington Great Law, Derrington Little Law, Hen Law. Well, actually we don't even know that for the objection. We just know about the two Derringtons. We know subsequently that from the updated position statement submitted by the council that other assets have come into play, namely...
Sorry, position statement, do you mean the updated statement of agreed matters?
No, I mean the updated position statement submitted to DPEA.
I'm sorry, during last summer?
Yes.
Right, sorry, right,
fairly
okay.
early on in proceedings.
Yeah,
Yes.
that added Bedshield, Dunside, Hen Law and Twin Law from memory. It's my understanding now, because we are entitled to look at these assets individually, there may be cumulative effects or collective effects, but that's another issue, that the individual objections on the basis of impacts on scheduled monuments extends to Derrington Great Law, Derrington Little Law, Hen Law, but not to Dunside and Bedshield, which are maybe collective contributors but not individually thought to be unacceptable. And then we have the undesignated effects or undesignated twin law cairns, which is part of the case. I want to be absolutely sure about that.
Let's let the council come back and see if we can clarify those matters, because I think that would assist all of us. So,
I think in the reason 5 for objection, I refer to the...
Sorry, Mr. Trinick, can you turn your mic off for me?
Oh, sorry.
I refer to the prehistoric cairns, and whilst I list Derrington Great Law and Derrington Little Law, it's just including these ones. I'm not giving them emphasis and that I'm grading them as such. So I'm looking at that as a whole. Prehistoric cairns, we're objecting on that basis. And what I think the other side has said is correct, that if you looked at them individually, yeah, but we're looking at them as a whole.
I think I'm clear on what you're saying. But I'd like to be absolutely certain. So let me just make sure I have then properly understood this. So you've looked at the prehistoric cairns in the area collectively to inform your position. You have particularly highlighted the Derrington Great Law and Derrington Little Law cairns as being, and views to them and over them and possibly between them. Although you can clarify that for me. I know I've got notes. I've taken a lot in this morning, so I will have the notes of it. And it's those particular things that are of concern to you, particularly when viewed from the area of twin law cairns, particularly when viewed from hen law, and there's also a concern with the hen law relationship, the settlement. So I think I understand that. And then if you'd have taken any individually, then, for example, Bed Shield and Dunside, then perhaps not, but you didn't take them individually, you took them collectively, and that's what you were looking at. Is that where we are?
Yeah, on the last point, yeah, we did look at them individually and were specific on which ones, and then, yeah, cumulatively looked at them and said, as a whole, yeah.
Just when you use the word cumulative, perhaps we can use the word together, because
That's probably a
I
better word, apologies.
take cumulative to have perhaps a different meaning, and which we'll be dealing with later. Okay, right. Do you want to respond then for the applicant, please, and then we'll see where we are.
I think I see where we are. I just make clear the reason I ask about these points and want clarity is that policy 7H2 is to be applied to individual assets, not collectively. It's to be applied to individual assets. There may be cumulative effects, but collective effect is something we don't recognise. So in the application of policy, it's important to know which assets we're actually dealing with. And I think I now have the answer in terms of what comprises individually, in terms of individual assets, the council's case in terms of unacceptable impacts. And they do not include Bed Shield or Dunside. Thank you.
I'm going to let you come back on that because that raised a matter you didn't have a chance to comment on previously, which was the matter of policy. So I'll let you respond on that if you want to. You can say something if you feel the need to. You might agree with what Mr. Trinick has just said. You might take a different view and you can tell me what that is if you want. And then after that, we'll see where we are.
No. Sorry.
So you've got nothing you want to say. You're neither agreeing nor disagreeing with the points he's made.
Neither disagreeing or agreeing.
Okay, it might be something I'd like you to address in your closing submission, please, so I can understand exactly where you, if you agree or disagree, whether he is correct on those points of policy. If there's nothing else, and if the applicant's got nothing else, I'll let you close if you want on matter 4. No, nothing more? Okay, that rather neatly lands us bang on 1 o'clock. So, excuse me, I think we'll take an hour's lunch break and we'll come back at 2 p.m, please, where we will be dealing with matters 5, 6 and 7. So matter 5 will be INH Forts, matter 6 will be cumulative effects, and matter 7 will be historic environment Scotland. At the moment, it seems plausible that we might get through by the afternoon, but I'll take soundings mid-afternoon. We'll see where we are. Right, well, have a lovely lunch, everyone, and I'll see you at 2 p.m. Okay, ladies and gents, the system is now back up, so thank you very much for your patience on that. Welcome back to day 1 of this public inquiry into the proposed Lees Hill Renewable Energy Park. Today's hearing session is covering cultural heritage. We got through matters 1 to 4 this morning, and we're returning shortly to carry on excuse me, to carry on with matters 5, 6 and 7 this afternoon. Now, before we do that, I think it seems that we will be likely to get through today's agenda before the day is out and we won't need to sit tomorrow, which I think invites us to look at whether we think the same is possible for Wednesday and Thursday, and if we're able to get through the landscape and visual session on Wednesday, then rather than not sitting on Thursday and coming back on Friday, there's an opportunity to decide whether we want to come back and do what is currently scheduled for Friday on Thursday. And that is a possibility. I noticed Mr. Campbell's obviously here, who would be an attendee at that. Mr. Smith was here this morning, but I can't see Mr. Smith just now. So I'm just wondering whether we... Can you hear me now? Yes. Whether we postpone this discussion until the end of the session in the hope that Mr. Smith returns to join us. How does that sound?
I don't know if he's coming back, but you can take it that I will communicate with him, whatever you decide. I'm sure he'll do whatever the majority of people want to do, and I think, if I may say so, the idea of trying to get everything finished by Thursday night is a good one.
Yep. I'll open that up for discussion just now then, and it'll probably be on the proviso that if Mr. Smith isn't able to confirm, I'll ask Christine at the office to get in touch with him separately. And then we'll be able to see whether it's something that he's able to do. So I'll invite the applicant to comment on that proposition first and give any views.
Yes, I think we will get through landscape on Wednesday at best. Thursday morning at worst, and given the brevity of the policy agenda and that I think the conditions issues will narrow down further, we could easily get through the rest on Thursday and finish. And that'd be my vote.
Ms. Thompson?
Yes, I agree with Mr. Trinick, and both myself and Mr. Wise are available to move to Thursday.
Mr. Campbell, I think.
Clearly your policy agenda is much shorter than one could have expected, because you don't appear to want to discuss any of the policy matters, only the socio-economic matters. And so if that's the case and the agenda holds good, I agree with Mr. Tunick.
Very well, yes. All the other issues were clear to me, I felt. So what I'll do is I'll ask the office this afternoon, this evening, to contact Mr. Smith, and I'm grateful if you could speak to him as well, as you've volunteered.
I have contact details for him, so it's, if I could ask Mr. Whitfield to step out and maybe phone him, we can get you an answer quickly.
That's very kind of you, thank you. It would obviously be to make sure that he would be available to do that, given that there's some particular matters that he'd raised, which I've included in the agenda on conditions, and I'm very certain that he would want to be available to discuss those. So if at the moment we can view this as almost agreed until we've heard from Mr. Smith, and yes, I'm very grateful that I can take you up on the offer of contacting him between times, and perhaps if it's possible and you're able to speak to him, you could come back to us just before we close today. Does that leave you enough time? I'm obviously conscious that I might be asking you to kind of step outside and make a phone call. Does that create inconvenience for you? You might have wanted to be in the room to listen to the discussion. You're okay. Okay, that's kind of you. Thank you. Right, okay, we'll wait to hear from you on that. Okay, if there's nothing more on that from anybody, no, we're okay. Right, then we'll proceed with where we are on the agenda. So we're moving on to matter 5, which is iron age forts. The council and the applicant previously appeared to differ in relation to the effects of the proposal on iron age forts, and this matter did not appear to be in the statement of agreed matters. Perhaps if you disagree, I might not expect it to be.
Perhaps I could just cut in at this point. The discussions over the break Iron Age forts do not form part of the Council's objection. As such, this section is perhaps unnecessary and we can move on.
Very grateful. Grateful. Thank you.
Very well, thank you for that. I think that clarifies matters. Which moves us on to matter 6, cumulative effects. Based on the statement of agreed matters between the applicant and council, the reporter understands the outstanding matters of disagreement on cumulative effects to relate to Twin Law Cairn HER 57449. Excuse me. Is this correct? If not, what is or are the outstanding disputes? And what is the rationale for the differences in position? I'll invite the council to speak first.
Thank you. Yes, the position is correct. We disagree on the severity of the cumulative effects from a number of wind farms, not just this one, but in combination with a number of other ones that are in application process, especially from these Twin Law Cairns, is that view. So we have things like Donside, we have Black Hill in application and existing wind farms. We have other ones which are also looking at this fringe area. The viewpoint at the moment from Twin Law Cairns, looking across to the Dirrington laws that we've discussed earlier, is wholly new for wind farm territory, and that is quite a difference.
And would it be helpful for us to have a look at the visualisation from Twin Law Cairns? Would that assist our discussion?
Yes, it could well do.
I'll just give everybody time to locate that, including me. Having asked, no, actually I've got the electronic copy here. So that's Cultural Heritage Viewpoint 04, which is figure 10.7A-E, I understand. I think I'd find it helpful if you could just take me through, Mr. Elliott, the positioning of wind farms and the ones that are of particular concern to you and how that builds up the cumulative picture as you see it.
Okay, we've got the first visualisation as is, with then the wire line across the way showing the existing wind farm Thalargo Rig and then the Dunside application.
So would this be, I heard you mention Thalargo Rig and Dunside, so if I look at 10.7b, I can see there's a photo and then beneath it is the wire line. So we can see in the photo above what I assume to be Thalargo Rig in the background there, and positioned similarly underneath, it's in, is that a dark blue, I think? And then sitting in front of it from this viewing position is an orange, which is, I think that's Dunside. And is that, does that say application stage from the key? I'm just looking at that. Okay, so are we continuing round in this field of view?
Yes, we're working clockwise around. We've started off looking westwards, now we're looking northwards in the next visualisation. So you have the Dunside application continuing around, and then similar, the mass of smaller in distance, but not a number, wind farms that are existing. So Crystal Rig is in their various numbers, Egg and Gore into part C. Again, working around the ones around Penman Shield, distant again. Docklands, Black Hill and so on. Again, applications in process for the Wedderley farm within the intervening ground. May yet be another application and an appeal to come. And then Lees Hill itself. So this is going into wholly new ground, and thereafter further to the right it is devoid of wind farms in any great numbers, or indeed any up until you get really far distant to the Barmoor. So from the twin lower cairns, we're being chipped away by these applications, but this is more prominent, as we've said, looking again to the Dirringtons, as well as into wholly new territory for wind farms and their turbines.
And what do you see as being the implications? And are we talking about this from the perspective of Twin Loch Cairns as the asset from which we're looking outward and seeing this? So is it the impacts and effects on Twin Loch Cairn itself, is it the cumulative impacts and effects on that asset that we're talking about here?
Yes, we're looking out from the cairns in those directions, as I say, westward, then clockwise, through north, through east, to ultimately southeast and looking towards the Dirringtons proposal.
So if we focus in on the proposal itself, we can see the proposal, can we, on 10.7c. So we can see the existing Black Hill in the background. We can see it's a green one. Is that scoping stage? Is that Wedderley Farm, I think you mentioned? And then overlapping but behind Wedderley Farm is the Lees Hill proposal. 3 turbines of which are kind of wholly behind that, and 3 turbines of which are to its right. So presumably that would be to this. Is that to the west of it? I'm just trying to look at my compass points.
So just before going on, can I check which set of visualisations Mr. Elliott is looking at? He's mentioned Wedderley, and that's been withdrawn. It's not on the updated visualisations.
In that case, I need to go to my hard copy one because I've got 10.7e. Right, just give me a second as well. I'll give you a second to find that in yours.
Even if it is updated, it doesn't.
Okay, I've got the correct one in front of me now. So this one is taken from the updated cumulative landscape and visual impact assessment, and this one therefore takes out Wedderley Farm, which was a matter we touched on earlier today, of course. So yeah, this shows the removal of that. So we have, I think, what you described in previously, so going from figure 10.7b, well, A and B, I suppose, to some extent, we see Philago Rig, Dunside, Newlands Hill, the Crystal Rigs and the Aiken Goals, and then on 10.7c, there's a grouping of some in the distance, Joy Drone Hill, Penmanshiel, Howe Park, Quixwood, someone will tell me whether that's right pronunciation, Moorhouse, and then Brockholes, Windshield, Monashee, and then the existing Black Hill, and then Gap, and then Lees Hill as proposed, and Barmore in the distance. So I think so. Can you just talk me through the nature of the concern about the cumulative effects on Twin Loch Cairns? And so I think we've helpfully established that the correct version of the document to be looking at. And can you just talk me through what the concern is with regard to the cumulative effect?
As I mentioned before, it's that.
Yeah, sorry.
As I mentioned before, it's that chip by chip away of the whole of the horizon view. In this case, then, should the proposal be carried forward, then you're going into whole new territory for those wind farms and the turbines that you don't get anywhere that isn't being impacted. As we've said before, if the prominence of the turbines behind Dirrington Little or the cairns on the summit or something, they are expanding that spread of wind farms around from Biview. That would be at Twin Low Cairns.
Okay, did you want to say any more before I invite the applicant to respond?
We've mentioned about scheduled monuments before and their designation by Historic Environment Scotland, and we've discussed for those cairns already. However, recognising that these aren't scheduled monuments, they are nonetheless significant, and the likes of Historic Environment Policy for Scotland, produced by HS and others, mentions that decisions affecting any part of the historic environment should be informed by inclusive understanding of the breadth and its breadth and cultural significance. So therefore the likes of Twin Low Cairns is culturally significant for the likes of my viewpoint in my work that deals with both designated monuments and for the greater part of undesignated monuments. So similarly, policy 2 of that historic environment policy statement for Scotland, which is referred to within BIA chapters and the like. Number 2 says decisions affecting the historic environment should ensure that its understanding, enjoyment, as well as its benefits are secure for the present and future generations. If you have in the wind farm, in this case, then you're nibbling away bit by bit, as I say, to that landscape. And back to what we were saying about settings before.
Can I just check? I think, were you quoting from something just there? Can I just check what that was you were quoting from?
Historic Environment Policy for Scotland.
Did you want to say any more then before I bring the applicant in?
No, that's fine for the moment, thanks.
Okay, over to the applicant.
Yeah, I mean, just to pick up on the point about the the kind of idea about the wind farms sort of chipping away, I think was the expression that was used. Again, I think we're back to equating visual change with impact. I think the fact that, you know, undeniably there are a number of wind farms already visible from Twin Low Cairn, and the proposed development would introduce further wind farms into that view. But again, it's not a case of assessing the impact on a view or assessing the degree of visual change. It's ultimately what would having a wind farm in that part of the landscape, how would that impact your ability to understand and appreciate the monument? Yes, your experience of the monument will change, but ultimately it's how you understand the monument in relation to its landscape setting. We've gone over that quite a few times with the other cairns in terms of this is a prominently located cairn, probably positioned to overlook settlement and possibly to interact with other cairns in the landscape. Although that latter point is ultimately a matter of academic debate. And you know, cumulatively with all of these wind farms here, it's our position that it wouldn't prevent you from arriving at that understanding and appreciation. I mean, in the response from the council, they only mentioned Dunside Hill Wind Farm and Black Hill wind farms as being the two of concern. Certainly, I know we've now gone on to list all of the other ones. I would just note that in relation to Dunside Wind Farm, which is considerably closer to the north of Twin Low Cairn, there was no objection to that development raised by the council, but based on what I've heard, presumably the same cumulative concerns would have applied for that particular development, so it's not clear why the proposed development would raise further concern on top of that. So yeah, I think ultimately we're at a distance of 9 kilometres from the proposed development, and again, there's no, in terms of the Twin Law itself as a monument, we don't consider there to be any impact on the significance of the monument through change to its setting, and so on that basis the proposed development can't contribute to cumulative effects.
Sorry, could you just say that last bit again, please?
Because we've predicted no impact on the setting of Twin Law, we don't then consider that it's possible for the proposed development to contribute to cumulative effects.
Did you want to say any more before I invite them back?
No, I think I've covered everything.
Did you want to respond to any of those points?
No, thank you. I'm okay.
Very well. Did you want to say anything by way of close or anything else?
Mr. Elliott mentioned HEPs. I'm just wondering which policies he was, I think HEP 2 you referred to, was that?
Numbers 1 and 2.
1 and 2. Well, HEP 1, I think we would say that, well, it says decisions affecting any part of the historic environment should be informed by an inclusive understanding of its breadth and cultural significance. I think we say yes, precisely. The 3 stages through thoroughly. In relation to HEP 2, it's high-level stuff. Decisions affecting the historic environment should ensure that its understanding and enjoyment as well as benefits are secured, present and future generations. Again, it's very high-level advice. I'm not sure how it really informs the topics we're discussing on the agenda, which are better informed by managing change setting of the 3 stages. But I don't disagree with what's said there, and we would say yes, we're in concert with those policies.
Okay, thank you. If there's no more then, we'll move on to matter 7. So matter 7 covers historic environment. Scotland. Oh, Mr. Trinick, would you mind turning off your mic? Mr. Trinick, would you mind turning off your mic?
Sorry.
That's all right. Okay, so matter 7, historic environment Scotland. So as noted in the applicant's hearing statement, and I know we've touched on it at various points today, historic environment Scotland did not object to the proposal and does not suggest that it should be refused on the grounds of cultural heritage impacts or effects. And therefore there's a degree of difference between that and the council's position. So firstly, is that synopsis accurate, and how should Scottish ministers treat the council's advice versus that of Historic Environment Scotland? So I'll come to the council first, please.
That follows on from what I was saying within matter 6 there about the Twin Law Cairns. So is the synopsis correct? Yes, we do differ between HS and myself. However, I've just mentioned the likes of the HEPS policy there, and thinking more broadly about the social value, not just the immediate settings of the monument as well. That
Sorry, what was that value that you mentioned beyond the
social value?
Social value.
Yes, the Twin Law Cairns, admittedly, they are the reconstruction with the existing pillars over a prehistoric monument, but they are socially having some value in that was a specific creation and amenity point.
And is value, I suppose you mentioned social value, is that something that an environmental impact assessment might pick up in terms of value or sensitivity of an asset, and then compare that with a magnitude of change in your consideration? And might you expect, therefore, what you're talking about to have been picked up in that side of an environmental impact assessment rather than possibly in the magnitude of change, or are you talking about both or something else?
I would expect it to come from that, not necessarily within the IA world, but within the general heritage awareness or heritage landscape as a whole.
Okay. Did you want to talk about any other points before I invite the applicant to come back?
other comment perhaps to make is that I'm unaware of Twin Low Cairns ever being assessed for scheduling. It may well be something that has been carried out. It may be something that could be carried out to assess if it is of the same ilk, the same monuments of that prehistoric origins, and therefore of the same value.
Sorry, can you just explain that to me? So, as I understand it, Twin Low Cairns is not a scheduled monument. That's correct, isn't it? It's not designated for that purpose, but you understand it to be possibly contemporary with other Bronze Age cairns in the area. But you also mentioned that it had been rebuilt at a recent date. So I'm just trying to understand what it is you're asking me to take from what you've just said.
I'm asking you to take that there are those undesignated monuments that have never been assessed for designation in the first instance, but I'm also making the point that Twin Low Cairns has the potential to be determined of designation quality. It is of the similar ilk in the origins of the cairns to what we've discussed for the Derrington, Henlow, etc.
But it's not designated at the moment, is it?
It is not designated at the moment.
Can I just ask then, is the purpose of the process that we are engaged in today and as part of this exercise to consider whether something ought to be designated or not, in your opinion?
It would be certainly useful if it had been considered for designation.
I'm asking you, is it my role to designate something or recommend something for designation or not?
No, it's not your role to for designation, but it is something to recognise of the historic environment that not everything is designated, nor has it necessarily been assessed for designation.
Okay, I understand. So you're saying to me non-designated assets are not unimportant, is that
right?
Correct. Okay, and and are you saying to me that this one, to your understanding, has never been assessed for whether it should be designated or not? It just isn't designated?
I know not of any designation that has been carried out as assessment for this site.
Okay, I think, as I understand it, the point you wanted me to take from that is just because it's not designated doesn't mean it's not important as an asset. And I understand that point you're making. Did you want to say any other things before I invite the applicant to come in?
No.
Over to you.
I mean, just to go back to the question about the Council's advice versus that of Historic Environment Scotland, I think just really the key point I want to make is it's clear that Historic Environment Scotland have followed the managing change in the historic environment setting guidance. The three-stage approach to that has been demonstrably followed, as has the EIA handbook. They've come to an assessment based on their understanding of cultural significance and have assessed the impact and have related that to policy, which differs from the Council's approach, which we consider primarily relies much on assessing the degree of visual change towards a heritage asset. So in that sense, it doesn't balance all the other factors of setting which contribute to the significance of the monuments. So in terms of that, that's where we think that the Council's advice overstates the magnitude of impact, and ultimately we think that little weight should be given to compared to that advice given by Historic Environment Scotland.
Did you, no more? Okay.
Nothing else, no.
Did you want to respond?
No.
Did you want to say anything by way of close, or is that... Okay, well, that takes us to the end of the agenda covering cultural heritage matters. Firstly, thank you very much indeed for your contributions to that. It's been extremely useful for me and will assist me going forwards. I just want to return before we finish today to the matter of contacting Mr. Smith. Mr. Campbell's about to come in, I think. And
yes, we've been able to do that, and he is available on Thursday.
Thank you. That's very, very kind of you to have contacted him on my behalf. In that case, we will do as we've agreed then. We'll meet again on Wednesday, where we will do landscape and visual. We'll start at 10 a.m, as previously agreed. The expectation is that we'll either get through all or the vast majority of that, and then we'll come back on Thursday at 10 a.m, and we'll do any remaining parts from the previous day. We'll do policy, and we'll do draft conditions. And I'll ask the office to be in contact with Mr. Smith separately about that. Is everybody content on that?
You don't need to do that. We've told him he's to be here on Thursday, and he said he can come.
I realise that, and that's very kind of you, but obviously with him not being here, I feel it's incumbent on me to at least contact him and advise that I'm aware that you've kindly liaised with him on my behalf, and that we understand he's coming, so at least he's got that. But okay, it remains for me to thank you again and wish you a safe onward trip. And please remember, if you don't leave any valuables, please make sure you've got your car keys, because we'll be locking up. And if you've used any tea or coffee cups, congratulations, you need to wash them as well. And there's 2 sinks in there, so I sense a race coming along possibly. But yeah, safe onward journey anyway, and I'll see everybody on Wednesday.